You saw the thumbnail. You saw the title. You know what we're about to do. Welcome back, everybody. This is day 103 of the YSL case, and we are back. Thank y'all so much for hanging out with me on this morning. So today we are going to be jumping back into courtroom. I think it's C is in Charlie, courtroom C with Judge Paige Reese Whitaker, as well as the rest of the cadre cast of YSL people. The cameras have just gone live, so let's go ahead and get that on. They are not playing games in 24. They said, we are not playing. We're going to get this thing underway. Hey, 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 what do you say? So let's bring that on, Jason. Wow, they are already here. They're not game playing at all. Wish I could do a mic check, but we have to see. Please let me know if you can hear. Hopefully you can hear me, but if you can hear them, it'd be really great. Once they click on, just please drop a one in the chat when you can let me know that you can hear. But yesterday was interesting. It did not go the way I planned. I'm glad that I am not a betting man because I would have lost all my money. Because I'm telling you, I was speaking to somebody last night. I was like, man, I was so confident. I was so confident on yesterday. I would have bet entirely too much. I'm so glad it didn't go like that. But so yeah, yesterday did not go like we anticipated at all. So today I'm gonna tamper down any expectations of anything happening. We still have the two motions to recuse the prosecutors. I'm just gonna bet against myself at this point and say it's not gonna go the way I anticipate. But we'll see. We will see for sure. And then the rest is just a little bit of horse trading, a little bit of argumentation is supposed to be happening. And we are going to ultimately see how this shakes out. But I do want to hear what you all think. So tonight, I will be having, let me double check, make sure before I say that too fast. Because I was sitting here scheduling this morning and I want to make sure I'm not misleading y'all. So tonight is the 31st of July. So tonight I have a live stream scheduled with eBand Films. They've been also doing the YSL case with some really deep dives into that. So they're going to be coming on, as well as I have a couple other YouTubers and law tubers that I've invited to come on to just kind of panel, talk about it and whatnot like that, and hear what their thoughts are. So that'll be tonight at 7 o'clock. So hopefully you can come on through. Good to see Tawanda in the building. Grace and peace to you. Always good to see my good friend Q in the house. Thank you so much. And on deck is Transplanted Texan. I appreciate it. We got about 25 of y'all that are watching. I appreciate each and every one that clicks that like button. It does let me know that you like this kind of content. You like that Christian male perspective on social and political issues and commentary, because that's what I do. So we've been talking about this case for quite some time, simply because I live here in Georgia. My name is Jason. I do live here in Georgia, just a little bit outside of Fulton County, outside of their jurisdiction, so they can't go ahead and extradite me. But I enjoy talking about this because it's my state that I live in and my state that I care a lot about. And we don't look that good. We're not looking strong. Let's just say it like that. We're not looking real strong in these streets. So I like to talk about this because it does give me an opportunity to hopefully see some things and shed some light on some things that we need to improve on here in Georgia. So shout out to Black Law Student, who was the stream sponsor on yesterday. Thank you again very much to the Black Law Student for sponsoring the stream on yesterday. Shout out again to Q. Appreciate y'all. And so that's the reason I talk about these topics, because I do find them extremely interesting and extremely engaging. So as we are digging into this today, hopefully we have something good, and we'll gain some good information from it. So let's get at it. Let's see who else has popped up in this here chat. I appreciate it. Bang. All right, we are rocking and going, popping and locking. Today's my last day of having a rising senior and a rising freshman of high school. Tomorrow, officially, I will have a a senior and a freshman in high school. Pretty wild, pretty wild. They are doing some they have some uh all the clubs meet today, and it's kind of like an open house for clubs today. So they're excited to go check out the clubs. And my big girl's going to take second born around school, make sure she knows where she's going to be tomorrow, so she don't get lost. Fire in the hole. Let's go. Good to see you, Laura. Thank you so much. Good to see you, Robin. My auntie is not playing. I told you my sister not playing. 8:45. Drop a one if you can hear everything. Man, she didn't even take roll call. Whoa. Somebody just said they didn't have any sound. Hold on one second. Can y'all real quick just confirm that you can hear? What's wrong with the audio? Hold on. My phone is blowing up. No sound. Got you. They can hear me, but they can't hear them. Okay. All right. Give me 1 second. I apologize for that. Thank you so much. No sound, they say. No sound. Well, that's not good. All right, let's try this again. They can hear me, but they can't hear them. Okay. Mm-mm. All right. Give me 1 second. I apologize for that. All right. Let's try that again. Sorry about that, y'all. I appreciate it. Always something good. Maybe that'd be a good sign that today's going to be pretty enjoyable, engaging. Hopefully, that's going to be a good sign. Let's see. Some reason or other, the sound is not coming through, but we will make that change. We got that. Oh, they switched seats and the whole nine. All right, let's get this fixed. All right, so drop that back in. Can y'all please let me know if y'all can hear?
And I'm, has anybody thought through yet, and maybe we'll have ready soon any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony.
Perfect. Thank y'all so much. I apologize.
And then
for
I'll
that.
entertain what we're gonna, I am going to say about the fact that here I am instead of Judge Glanville. But
Oh, it's
for that,
green.
I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I would and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville.
Oh my
I would
gosh.
like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction to the extent anybody wants to provide one. for me
Still
to
want
think
his
about.
pound of flesh. He said, "Give me my pound of flesh."
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief of the main case. I will get the exact language that I'm speaking of.
All right, great, thank you, I appreciate that. Okay, anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday.
No,
So
ma'am.
that needs to accelerate.
Okay, we will
Good
work
luck
on
with that.
accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
The giant list of
the giant list of
okay,
exhibits.
yes, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yes, Your
For
Honor.
that. I thought you meant Mr. Copeland's testimony.
No,
Okay,
Your Honor.
all right. My misunderstanding.
That's what they're
then.
doing.
Okay.
You're right, Q.
All right. So with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let the
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things. But what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this and we're okay with that ruling?
We believe
That's
out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
I just want to, we don't think there's many, at least from the state's
All
perspective.
right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before
one.
the Monday.
Sorry, I'm sorry, just so that we're clear for the record purposes. This
Come on.
is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about.
Maybe more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript.
Right, come on.
We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things.
Come on.
The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone.
Drop a fire
Why did Judge
emoji in the
Glanville,
chat.
when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that
your love
says
is
not only
mad.
I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My head skin's been
Understatement.
coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything.
Bald
That's
head
my
brothers
stance.
unite.
Okay, thank you.
Woo!
And
Y'all give him a standing ovation.
I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel
I need to
on this side
read
of the
this
room
transcript.
are upset.
Black law student, help me out.
I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all will ask me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well,
if it says that in the
transcript will
though,
reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
Look,
if I can address the court briefly.
this is crazy.
I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's,
I do like the
got
green
it.
hat, though.
Thank you, Your Honor.
Yeah, switch back.
Mostly I want to make sure I bring it to the court's attention because, again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Shart, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to.
Are they talking about me?
but communicating in ways
They better
that are
not
not
be.
appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. And we don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot. So
well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say,
I'm
I
sorry.
haven't-
This
obviously you
case
just
is
filed
cooked.
it, and I haven't had a chance to look at it yet. But I will consider that in the overall context of
Wow.
the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. Yeah, if y'all feel like you need to get it off your chest, come on.
Oh,
Now's the time.
go ahead,
I got one more
Brian.
thing to
Look
say.
at you.
And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't
This is
either.
amazing.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you.
I
I will
do not.
tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money,
Oh, it's
I would keep
it's
it
a
out.
wrap.
But since it's only about Mr. Kendrick's life,
Come on.
that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know.
It's a wrap. It's
I don't know.
over.
Obviously, I don't know what to say right now either. But
I'm
I
with you.
think that, well, again, I understand frustration. Let's be careful about disparaging a respected judge.
That's
I
not the
do
issue.
think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but
Stop defending Glanville.
You're
all
right.
right.
Those were not my words. Those were Chief Judge Glanville's words.
Right.
This was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again,
In a few
I
minutes.
don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to
Can
evidence?
I want to say something.
Mr. Steele.
Oh, it's a wrap. Oh gosh. It's still. Oh gosh.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put in at all. So I understand what you're doing.
Okay.
We're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said yesterday. I agree that that's the law. I don't believe that it should come in at all. So before you tell us later, hey, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but
I had one thing. Just another layer of that. Oh, I'm sorry.
go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So
Okay.
there's like two layers
Sure.
of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement. And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a well, that was a lie can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie. And I'm
Yes,
paraphrasing.
yes.
That is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele?
Yes.
So that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement in to come in.
Okay, and 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Come
Your Honor, you
on.
can give us a moment just because
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or
Come
more
on. Come on.
to get ready for this. So I don't know what y'all thought we were going to be doing, but
Come
yes,
on.
I'd like to hear it. So
My sister
if you
ain't
need a minute
playing.
to get me the law, go ahead.
So don't quote your cousin. Don't quote how you feel. Oh, this is going to get ugly.
Is there, we can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else could we do that's productive?
Your Honor,
Yes.
I would like to make records. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
If your court thinks that's a good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well,
Ooh.
tell me why that matters, because what may have been the actual truth and what Miss Love and or Miss Hilton perceived and therefore caused them to want to speak to the court ex parte don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. I will then, I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness. He spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that it did not go to the holding or the ruling, and she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a honorable Superior Court judge who made that ruling that's cemented in our case, that, you know, I forget the line, but something like it was, maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland.
Facts.
I would have been able to be, because the Judge Glanville said, do you want to be, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to
Okay,
make
well,
is
I'm
John
going to make a
Melnick.
substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, oh, you seem to want to talk to him, so I will let y'all talk privately, which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interest, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally, has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, Lawyer Love said, John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Melnick.
She did say that, yes.
And Mr. Melnick said that is just a flat out misrepresentation of comment.
Okay, well.
So I just want to get the record straight, because Georgia law, and I gave you these cases in a footnote. Georgia law right now, and I know I'm very familiar with this honorable court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding, it's over. The case, no one looks at prejudice. But the two cases that came out in April, one of them may have been in January, but I cited them in the footnote of my motion to just educate the
Okay,
court.
well, if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong,
Okay,
and we need to show prejudice,
okay. With regard to,
like federal.
give me the cases in what
Step back.
okay.
But so I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
Okay, well,
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this
No, that was before
critically
then.
important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton, Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there's not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rule or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, right, and a fair tribunal. That's constitutional as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact and we investigate. Mm-hmm. But I'd like to spread that on a minute. So I raised that. I don't know, right, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand. And I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday the 10th? Okay. So let me make that determination.
I'd like to call him if you change your ruling. Both of them, Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, I would think that he can then say, or tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this. I want to get it right.
All right. So you haven't talked to him yet about what? All right. Well, obviously, I'll give you a chance to talk to him before you make a proffer because you need the proffer to be accurate.
Okay.
All right. So that's not something we can do right now either.
Okay. Thank you.
All right.
Wow.
So
this case is
what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay. All right, let's come back at 11.
Oh my goodness. She had to take a comfort break.
Doesn't matter to me.
She had to go take a comfort break. Oh my goodness.
So if that's fine, that's fine, but I'm not going to ask them to stay here. They've got a lot of other work to do too. Okay.
Yeah, I don't understand this either. Oh my goodness. My goodness, my goodness. Okay. They came out the gate hot like a firecracker. Shout out to Max Shard. Man, he was livid. All right. I think I'm going to get a copy of this. Read that yesterday. I have to admit, I was exhausted yesterday and I didn't read it. So I'm going to get a copy of that ex parte that was shared with them at the end of the day yesterday. Real quick, I'm gonna grab it and we're gonna look at it. But because apparently it sounds like there were some bad things said about them. Like, yo, there was some bad things said about the team, man. It sounds pretty, and of course it might be, slightly embellished. I'm not assuming that they said it exactly like they did, but okay, let me find it real quick. But that was wild. And I don't know. Well, let me from my understanding, Judge Whitaker is campaigning, if you will. I don't want to say campaigning. She is working for a Superior Court or Supreme Court position. I think that's fair to say. She is trying to show that she deserves that position. And one of the things that Supreme Courts do is they clean up messes. They fix messes. So if that be the case, this is a quintessential example of a mess that a judge in the Supreme Court or Superior Court would have to clean up. So it's almost like, okay, let me see. I think I found it. So that's what I think, in my opinion, is going on. She wants to prove, I'll say prove, I don't like to say that. She's showing that she has the ability to take a horribly messy case out of it. Okay, I don't see this file from yesterday. Hopefully a Black law student will come through and rescue your boy. So what I think she's trying to do, and I think because a lot of people are asking, well, why is she not just throwing it? Not throwing it, but why don't she just close it out? I think she's trying to prove that, look, I can get this thing back on track. So if you can imagine you're riding a bike and you're riding pretty fast and your handlebars get out of sync. Sure, she could just slam on the brake, but she wants to prove that she can fix it and get the handlebars back in proper alignment while the bike is still riding. I don't think it's the best way to do it. Maybe that's not a good example, but any kind of vehicle that you might be riding where if something could happen and you have to be strategic and you have to show professionalism and show your mastery of it, the linkage brakes on a on a snowmobile or something like that, and you got to be able to still navigate it while it's still moving. And that's what I think she's trying to do. She's trying to prove that she can get this thing back on track, because everybody knows, I live here in Atlanta, everybody knows this case is off the rails. But I think she's trying to prove that she can get it back on the rails and bring it into, get it delivered to a jury to make a decision. I don't think she realizes just how bad it is, because this is not just a situation where you just slam it on the brakes and kind of get it back in, slow it back down and get it back on track. I don't think that's it. This is a ship that's hit an iceberg and the lower 3/4 are flooded. Like we're not talking about a situation where I don't think you can resolve this. I see no way that she's going to be able to fix this. Because again, she's saying jury. They mentioned jury. I'm like, you do realize that you got to go and you're going to have to horse trade with these jurors. You're not going to just be able to bring the jury in and start day at 8:45. You got to go through and you got to poll all the jury. That's going to be a mess. That's going to be a mess because they're going to already find out. I mean, it's going to be it's the defense's opportunity to disqualify jurors, and that's going to be a mess. All right. So how come they didn't tell about the earlier meeting? I think that's a fantabulous question. Why did they not talk about this earlier ex parte? And I remember the Friday when Love asked for it, and I got to find that clip. I actually have the clip. I just didn't have it ready, queued up right now. I'm sorry about that. But I remember her asking, literally when Woody did that whole, I plead the fifth, you hear Love say, Judge, we like to have an ex parte. She says it in open court. So why was that not? Yeah, that's problematic. Yeah, and Laura's saying this right here. She's showing exactly why it's important for her to know exactly what has happened up until now in trial. Not read it. It needs to be seen on video. I think also look, hats off to Judge Whitaker because she has a Herculean task and you're trying to, be the hero and such of that nature. So I'm not mad about that. What I am pointing out, however, is that it doesn't seem like she knows everything that's happened. And there's been some key moments, especially with the second ex parte coming out, which I think is, if the first one wasn't reason to call it, a second one should be carte blanche. Like, what are we doing? They got caught with an ex parte meeting. Then at the same time, they're hiding another one. Discernment files. I mean, that is truth. That's what we're talking about. This is why people don't trust the legal system. And this is Bot all the way from Germany can recognize this. He can see this on the other side of the pond. Why can we not see it here in Georgia? This is why people don't trust the legal system. This trial has been beyond a hot mess. These defendants deserve a fair trial, and this ain't it. Look, Bot over there in Germany is picking up on our Georgia and Southern colloquialisms, already using the word ain't. Look at that, man. We corrupting globally, man. We corrupting them globally. Shout out to Big Bot. Thank you so much. Someone said the other day that the judge didn't get it. I don't think so. I don't know. Okay, let's just say for laughs and giggles that they just told the judge yesterday. The judge should have been infuriated with the fact that y'all had another ex parte meeting. The reason we're here is because of an ex parte meeting. And you're just now telling me Whitaker should have been livid about that. Now, let's say that she knew about it beforehand. Why were you still not livid about that? This is the reason why you're in trouble. Imagine, if you will, you're in elementary school and you get into a scuffle with another student and y'all are throwing hands. I mean, beating each other to a pulp. Moms are called, all that kind of stuff like that. Your mom comes to the office and she finds out, oh, well, yeah, little Johnny and little Sally, they were in a fight yesterday too. And they beat the brakes off somebody yesterday. Well, hold on, wait. I didn't know about this. If you had told me about the fight yesterday, we wouldn't have had the fight today. Do you see what I'm saying? This is the exact same thing. I'm sorry. I understand why Max Shard is like ready to throw hands. I understand why he's ready to throw hands. Why he's so angry about this? Because as soon as I get this ex parte, I'm trying to pull it up and try to multitask at the same time. And I'm not the best at it, so I apologize. As soon as I get it, y'all will read. I'm going to read it. She is trying to be careful, but I think, let's be honest. If she had came in here and said, y'all, this is an absolute dumpster fire. What the devil are y'all doing? What is going on? Y'all, this is ridiculous. I'm calling mistrial because y'all don't know what y'all are doing. Goodbye. Get up out of here. Hopefully get your parking pass validated. Have a good life. Goodbye. Would anybody have faulted her? Would anybody looked at her and said that she was not being fair? Because she's trying to rectify this. She's pumping as hard as she can to get the water out the lower thirds of the ship. But ma'am, the state is drilling more holes on the other side. They're literally holding things back from you. Because again, I think most of us would have been like, wait, another ex parte meeting? I mean, come on. From what Ashley Merchant said in court, this is an automatic mistrial. I have no idea how this is not. Thank you so much, Bruce. Thank you so much. She needs to go ahead and call a mistrial, and it will be blamed on Glanville instead of being brought down on herself. Home office, can you text her? Because to me, that makes so much sense. Like, everybody's blaming Glanville. I'm sorry. I'm back in this dump truck of bovine scatology right on up there in the Glanville and dumping it on his front yard. Don't dump it. It's going to get dumped on somebody, whether it be on the appellate court, whether it be on the Georgia Supreme Court, wherever. It's going to get dumped on somebody's yard. Let it be dumped on Glanville's. He's the one that caused the problems. Let me double check. Let me see where. Sorry about this. I'm trying to get that ex parte. Emailing a lifeline. But again, like, why I understand she's trying her best. She's driving down a highway going fast and she gets a tire blown out. So she's got to keep control of the vehicle. I totally get it. I'm not mad about that. But go ahead and turn and get yourself to a safe place on the side of the road or to the shoulder. Go ahead and do that. Don't keep trying to drive and fix a flat tire while the car is moving. That makes no sense. Get to a place, and then from there, you're gonna have to get off the off ramp and go get the tire repaired. Get off of this. This is just go ahead and call it. She on the phone. I think you're talking about either you're talking about Love or you're talking about Paige. I think Love is trying to figure it out. She needs to go ahead. Oh, I'm sorry. Just read that. Thank you so much. Great comment. Brian Steele is not on his game, but he's for sure wish Adams would get up there. I think he's doing better today than he was yesterday. Yesterday, I think Brian Steele was slow burning yesterday. I don't know what happened yesterday, but I got your point. It is possible she's trying to show just how absolutely broken it is. If she calls it now, it might still be questioned. I understand what you're saying. I agree with you, Laura. I just don't think many people would question it from what we've seen. And I'm saying, I live here in Georgia. I don't know a lot of people that believe this case is going to be tried fairly. Most people know, like, oh, it's going to get thrown out on appeal. Oh, it's going to go this, that. Like, it's broken. It's broken. And I think, I'm sorry, for them to roll up in there with yet another ex parte meeting is, I'm sorry. For them to roll up in there with another ex parte meeting, another one, by the way, that they did not mention. Yep, I got the link. Yep, this is Love saying it. Yep. Let me pull this in. Okay, I'm gonna pull in the we're gonna jump into Twitter real quick, where Adrian Love asked for the now infamous ex parte. All right, so we're gonna stop sharing this for a second, because that is, she said 11, I believe, for this. I think my sister said 11. Yeah, I'm still proud of Judge Whitaker. I think she's trying her best. I just don't agree with her avenue of success. Path to success, in my opinion, is a little bit different, but you know, it is what it is. So let's get rid of this. Let's bring this back in. So what we're looking at is this is the day, this is June 7th, and you're going to hear Adrian Love ask for an ex parte.
State has a matter we need to take up ex parte.
Okay, all right. Lieutenant Walker has been asked by defense counsels as a corporeal body for them to be able to talk with their clients once you clear the courtroom.
Okay, go back because she says right in the beginning.
You need to take up ex parte.
Stop talking, Jason.
State has a matter we would like.
All right.
State has a matter we would like. You need to take up ex parte.
Okay, all right. Lieutenant Walker has been asked by defense counsels as a corporeal body for them to be able to talk with their clients once you clear the courtroom.
Because that's when they arrested Woody.
You need to take up ex parte.
Okay.
No, did they arrest Woody? No, they had not arrested Woody, if I understand correctly. But you see here at the top, this is June 7th. And all right, 1 second, everybody, 1 second. Okay, so I'm getting the full ex parte transcript sent to me right now. And I did drop the link to that Twitter post. Shout out to the Hood Lawyer who had it in their Twitter account. So you can see it and y'all can hear it. It's right at the beginning where Adrian Love asked for the ex parte. And then when I find the clip, I'll make a longer clip of it so we can get like maybe a little bit more context of what was going on in court at that exact moment. So, but at least it's there. All right, what does Laura say? Laura says, DWC, I get what you're saying, but she's looking out for her career as well as the case. I think she is going to call it, but just building a foundation as high as possible before knocking it down. You know what? I'm not mad about it. It's just really difficult to watch because I mean, you can hear the frustration in Max Shard. Max Shard was livid, and and Doug Weinstein and Brian Steele again is kind of low key. I think he's trying to keep the play against the different energies and enthusiasm. So I'm not mad about that. All I'm saying is that if she's doing that, that's fine. I just don't think that it's going to bode well. Like, just do the right thing. All right. Phone call again. 1 second. This is interesting, Adrian. That's interesting. She doesn't want to look like Judge McAfee in the Trump trial. That's why she won't say that the judge is biased. Okay. I mean, I can kind of see that. I disagree with her if that's what she's trying to do. I disagree with it, but I can kind of see that. And Laura says again, I'm assuming that they all need to file new motions for mistrial based on the new ex parte, right? If they don't, then it cannot be part of their appeal, I believe. Well, I'm pretty certain that there's new ones being filed. Now that I think that's probably, if it wasn't already happening, I think it's probably happening. All right, here we go, right here. All right, let's see how long this is. Oh, there's a transcript. Oh my gosh. It's not terribly long. Oh no, it's not long at all. See, I need Cat now Williams so we can do like the voice work. Dog, somebody tell Cat to come over here so we can do the voice work. If anybody's familiar, Cat Not Williams and I did a reading of the original ex parte, and it was we just did the male female playoff. It was really hilarious, and I think it added a lot of I think it added a little bit of color, a little flavoring to it, a little Lowry's to it, if you will. All right, what we got here? All right, let's go. That's not bad, Jason. That's not bad at all. Oh my gosh. Okay, so this is a part of the supplement to Kendrick's motion. So up here, I'll drop the whole link. This is Kendrick's, Mr. Weinstein's filing for. He's added this as a supplement, and his supplement is the ex parte transcript. So 2:45 p.m. I'm assuming this is on June 7th. Let's just read through it. I mean, we got time. Let me just double check. I got court up. Let me make sure I got just in case okay, court is up. Perfect. Miss Love, Judge, the reason that I specifically wanted to talk with you is that I have concern about the representation being made of the representation of Mr. Copeland. I'm concerned, and I am sort of not. I wanted to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or any member of the state any legitimate concern that he has regarding Kenneth Copeland's testifying. What we have seen is a physical interactions with persons besides Mr. Copeland that would indicate that Mr. Copeland is not Mr. Melnick's primary priority. Oh, okay. So again, I mean, they're calling it right there. She's reading it right now. Oh no. Darn, I love when Cat and I do it. All right. Q, you need to jump on. Get out of your meeting and come on, Q. We can read together. What we do know is that when the fact that he's willing and wanting to leave, number one, he left twice after the court ordered him to speak with his client. And it would seem his actions conveyed that it is not Mr. Copeland's best interest that is his priority. Okay, that's where the email came in talking about, is this my priority? And where he infamously said, use the expletive. Got it. Miss Hilton was not speaking with Mr. Copeland at Mr. Copeland's request at the time that I announced that Miss Hilton was calling Mr. Copeland. What I did not know is that she is trying to tell you to give us a minute because Mr. Copeland was feverishly, and I will let her speak as to how that went down, feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that did not come from any of us, the court. What was that, Ms. Hilton? So let me just put in order of operation. I got up because Deputy Chief Long said he wants to talk to you. Come out right now. So when I went into the room, Melnick either came in or came outside, and what Mr. Copeland said, and I think that he wanted to get some autonomy. I want to talk to you. He's like, I've already talked to you, but I want to talk to her. And Mr. Melnick kept like blocking him being able to talk to me. All right. So Melnick is clearly there. He's not blocking because he has nothing better to do. He's actually his representation. Okay. Like blocking him being able to talk to me. So eventually, I was like, well, clearly you want to talk to him. So I'll step out and you can come in. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. So by the time I got back in there and he started to talk, that is when I don't, do you need the plug? Okay. It was plugged in. President Firstborn. All right, now threw me off, man. So by the time I got back in there and he started to talk, that is when everybody said, come on, the judge is waiting. And that's why he stormed in angry. Miss Love, he being Mr. Copeland, because I think he was trying to convey to me some concerns he had. And so I was trying to have that conversation. But Mr. Copeland and I have been having really good conversations since Friday, like very, very good conversations, just not even about the facts of the case, but just life experiences. So I think I was building a rapport with him such that he thought I lied to him. So I was trying to explain to him. Okay, I want to stop for a second. I don't have any problem, and I don't know the decorum of attorneys talking with possible witnesses and whatnot like that. But again, to couch it as if he did not have counsel does seem to be a lap too far when it's clear that she knows that he has counsel. My point, Miss Love. And by that, she means today. Today about what was going to happen because of what someone conveyed to him, Ms. Hilton. We believe that something was being conveyed. What happened is, as Mr. Copeland is walking back into the courtroom, Mr. Melnick and Julie would have to, Miss Langquat would have to confirm this, but he said they are going to hammer you. And that made me ask Miss Love, did you say something about hammering him? And I don't know who. Miss Love, nobody did. Nobody did. It doesn't make sense. You would say that to him. And that was the court. Miss Love, we never said that. But anyways, okay. So whatever that communication was, that's when he stormed in and got angry. And the result I got was what he gave when we started. So at this point, I'm very concerned, Ms. Love. He, meaning Mr. Copeland, stormed in and got angry. The timing of everything is, again, Ms. Hilton, everything is very ironic. We laid it out on a record earlier about what happened, and I don't believe Mr. Copeland's best interest is being served at this moment, given that, Mr. Melnick was willing to take a vacation and let him languish in jail. Boy, they are so grimy. So they're calling him out for going on vacation, which was planned before. But please understand, remember, Hilton, and I think it's very funny that Hilton is the one that is saying this, and she's about to take a medical vacation or some kind of medical break next week. So she's doing the exact same thing. Just seems interesting. That is very hypocritical. I can kind of see why they're mad and languish in jail. And that is not. We have communicated that we never wanted Mr. Copeland to go to jail. We don't want him in custody. We don't want any of that to occur. And so, Ms. Love, and Mr. Melnick has not spoken. He has not relayed. What we did get during the break was an email from Mr. Melnick. I don't know if he had to have been blind copying someone else. This is the infamous email where he says, yeah, I got you. Someone else. The only two people I could see on the email were Ms. Hilton and myself, but he referred to me in the third person and said, these are the communications between myself and Ms. Love. So I asked Mr. Melnick, whose interests are you concerned about? Are your clients or Mr. Steele's or Mr. Shard's? Because prior to, and this is not the first time Mr. Copeland has said he doesn't represent me. This is not the first time Mr. Melnick has. And let me be real clear. When he spoke of what was happening before him representing Mr. Copeland and he told me that he didn't represent Mr. Copeland. He told me. The court, Mr. Melnick told you? Yes, Mr. Melnick told me previously that he wasn't representing him. Court, you would not speak to the unrepresented party. I mean, I know you know enough of the rules to not, I'm sorry, enough of the rules to know that if you thought or intimating rather, that somebody was represented by counsel, you would go ahead and let them contact a lawyer. It's funny that the court is saying this. The Judge Glanville, is saying this. Like, I know you wouldn't violate the law, would you? It just seems like it seems wild. Or Mr. Copeland would have said, because I don't know as a witness, because he's not charged, if we could have had to Love, right? Because he's not charged. I don't think you have to, because there's no pending charges. But if he told you, I got a lawyer, I don't want to talk to you. But he didn't have to say that, though. They knew he had a lawyer. We would have left because, okay, I'm just trying to think, like, back to the conversation that Hilton was having with Woody before he came in. You knew he had a lawyer then. I don't understand. What are we missing? Because people counsel that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking to you unless my lawyer is present. Ms. Hilton, we have done that with a number of our witnesses here. So this would have been no different. Exactly. And this is Love. And we would have, I'm sorry, I don't mean to cut you off. No. Go ahead. That's it. We actually communicate, especially when either they are incarcerated or subject to having their sentence revoked as a result of their testimony because they pled guilty here. We only reach out to them through their attorney because we want the attorney to speak to them, and for that to be, because that's the best way, in our opinion, to get a rapport that elicits a truthful testimony. Okay, I can understand what they're doing here, but if they thought truly that Woody had no attorney at all, I'm wondering, should they have asked, especially if they're thinking that it's possible that he has an attorney. I mean, why would Melnick be there if he wasn't his attorney? It just seems weird. So in this particular instance, there was not that, number one, there was not that communication made by Mr. Copeland that there was either a need for that, and two, there was not a need for us to be concerned about it because he doesn't have charges. But you've had him as he has an attorney, even without charges. Okay. It just seemed like they're deliberately not calling Mr. Melnick, even though they know Melnick has in the past been the attorney. Ms. Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking to him about, the statute of limitation has run. He didn't do the murder. We know that. I mean, so I don't want to get into the facts of anything. What I'm trying to get at is the fact that Mr. Copeland, I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interests of our witness. Okay. I believe that in conveying in the court, conveying to the court, that Ms. Bumpus is going to stand in his stead. Ms. Bumpus has been, so this is, okay, this is on the 7th, right? That Ms. Bumpus has been, she had to be, she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. No, she hugged DeMonte Kendrick. I'm sorry. In fact, she hugged DeMonte Kendrick and hugged Mr. Williams. And that's how Captain Kendall saw her. And Captain Kendall had her taken out. Miss Love, she expressed dismay and concern in challenging her right to go interact with that matter with the defendants. So they got issue with Bumpus. Okay. Very interesting. Okay. That's just interesting. Like, why are they throwing Bumpus in under the bus? I don't know, man. At this stage of the game, I just think they're just doing whatever they like. They like doing it. This is what they're doing. All right. Mr. Copeland has been reaching out to speak to Miss Hilton, and that communication is being blocked by someone Mr. Copeland didn't reach out to. So you're saying that Melnick and now Bumpus by default are not his attorneys, but you knew that Melnick was at one time, and the only reason Bumpus is there is because she was his attorney. You notice no one said Mr. Copeland called me. He never said. When we put on the record, when Miss Hilton said, the way I understand it, Mr. Melnick reached out to Mr. Copeland because the first time we heard an assertion like, he's going to plead the fifth, is when Mr. Melnick sent an email to Miss Hilton and myself and had copied on it Mr. Steele and Mr. Shard last night. Why would he have done that given? And that's the state's concern. That's the point. But here is the challenge. The challenge is you have privileged communications. And unless you've got him being the client, disclosing to a third party that wouldn't be subject to the privilege, that is the only way you're going to, Miss Love. I don't disagree with that. But what was he trying to say here? Okay, so I'm thinking if Melnick sent them an email saying, hey, my client is going to plead the fifth, when you want to know that, it seems like the right thing to do, to let everybody know, like, yo, my client's going to plead the fifth, just so everybody knows. Why let the state know, but not let the defense know? Or why let the defense know, not let the state know? It seems like you would want both of them to know. Miss Love, I don't disagree with that at all. But if Mr. Melnick, and the thing that got me the most is Mr. Melnick is not looking at Mr. Copeland saying, Mr. Copeland, I want you to stay out of jail and I will be here with you. And if they ask you anything that touches upon something that you and I talked about, I will stand up and assert your right. He didn't do that. Okay, I don't know if he did. So I can't argue that. I understand what she's asking for. It just seemed like a lot, but okay. What he did was he looked over at the two people and said, like, I did what I could, shrugged his shoulders, held up his palms of his hands like this, as to say, I tried. Okay, this is the infamous shoulder shrug. And okay, apparently shoulder shrugs are co-conspirator, are RICO quality. I don't understand that. There's no reason he would be looking to the right to counsel for the defense like I tried after Mr. Copeland said I'm not going to testify. That doesn't make sense. Okay. But you know what also doesn't make sense? The judge making hand movements to the state. That doesn't make sense. I mean, there's a lot of doesn't make sense in here. You know what I'm saying? The court. Well, there's a lot of innuendo that they have asserted themselves. They, being some of the defense counsel, have inserted themselves into this particular process. And that's what my concern is Mr. Melnick insertion of himself. The court. What are you asking me to do? What are you asking me to do? And what do you think that I can do? Wow. So you're taking, the referee is taking orders from the coach of another team, of the other team. Wow. I mean, that's kind of powerful. What are you asking me to do? What are you asking me to do? And what do you think that I can do? Wow. Okay. That's not bias. That's not bias at all. Nah, not even a little bit. That is the exercise. That is the homework for tonight. I wanted to let the court know that that is what we're looking into right now, because there is a remedy, because I have faith in the law, in our law. I love this thing. And I know there is a remedy, because this can never have been the first time this has happened. It has been addressed. I just have to find it. But I didn't want to be looking for something and not let the court know that I'm looking for, so you are not, so that you are not, so you are off guard when Monday morning or Saturday night or Saturday afternoon, interesting, we find it and send it to you, the court. Okay. So thank you for allowing us to audience with the court. I just wanted to make certain that we did it properly and we have everything on record. Okay, I want to stop right here. I don't think this ex parte is as bad as the previous one. Some of the things said in it, though, I do think, but this ex parte is actually the proper type of ex parte, one of the examples of a proper ex parte. But let's continue. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he talks about on the stand and any use of that. And the thing is that we won't ask him that, but this is what he said. Y'all might not, but they might ask me about some things that I have to assert my right on. And that would be a question by question basis. Okay, I don't know if he's saying the state or the prosecutor or the defense. What he is being influenced to do, we believe, by Mr. Melnick is through Mr. Melnick, because as we saw, Kenneth Copeland said, I will testify. Mr. Melnick, even after that said, he's asserting his fifth. He's asserting his fifth. I'm going to go talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Kenneth Copeland's freedom, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, I'm here with you. If there's something that I know will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail. Instead, you get Mr. Copeland, and you can see through his body language. He gets there in the court and he's smiling as if he's making a show of being taken into custody. After this, the man don't want to be in jail. He said it. Didn't he say he didn't? Didn't he say he don't want to be in jail? Hilton said that's his biggest fear. That's his biggest fear. And now he's in jail after Mr. Melnick asserted himself into the process. See, I don't think that's what happened. I think Woody went to jail because Woody did not want to be on the stand testifying. It's that easy. I mean, that's what he said. Okay. So we have to go figure it out. I'm not just laying it in your lap saying, go fix it. I'm just bringing this to the court's attention. This is a grave concern. Ms. Hilton, she's about to lose her mind because her biggest concern is that Mr. Melnick is actively harming a human being. And that's what she's maddest about. Okay. This is why I believe Brian Steele wanted Melnick to come in. I'm mad because it is stopping our trial and it's wrong. And that is not how the law is supposed to work. So we have two big old grave concerns that we are working to remedy right now. The court, okay. Well, like I said, I think that you brought your concerns to me. You know, without more, I don't know what else I can kind of do in terms of that. My comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have to do anything with you all's case. It really shouldn't, but I think it does in some way. Outside agitators love that too, and everybody else who I think are trying to influence. Okay, that is absolutely happening. Okay, now we get into the outside agitators. There's a lot going on. There is a presence. Yes, that is all I'll say. I mean, here's the court. I mean, but I see it in front. I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. And like I said, since we now know he's going to be potentially invoking, and he's going to potentially invoke, we'll see what his pleasure is. And I mean, this is love. Just the idea of somebody sitting in jail throughout this trial, but if that's what he's being counseled to do, and that's what he does, that's just wrong. It's wrong because a member of the bar is, in my mind, creating these circumstances. You know, he's going to do what the person he trusts to have his best interest at heart tells him to do. And that person, he doesn't have to tell us what he's concerned about. And just sit there. And when he sees the train coming, stand up and say stop. But he's on vacation to go on. So he can't be here. Boy, they are mad about this vacation. Boy, they are mad. They are upset. So Ms. Bumpus is going to be here. Ms. Bumpus hugging Mr. Kendrick, and Mr. Williams is going to be here representing the interests of Mr. Copeland, who is supposed to testify against Mr. Kendrick and Mr. Williams. Okay, I got to give her that. I mean, she cooking right there. I get it. That is where we are. That doesn't pass the smell test. I get it. I mean, I understand that part. I don't know if I agree, but I understand what she's saying. She's cooking a little bit there. All right, so they said 11 o'clock, and it's still up, not up yet. All right, okay, thank you. All right, and that is, okay, that's the end of it. And all right. I totally get what they're upset about. I just don't know if it's as bad as I thought it would be. When you read it, I mean, the outside agitators, the influence, the little shade, the little barbs thrown. All right, let's see what Melnick actually points out. All right, the Superior Court of the Fulton County, State of Georgia, supplement to DeMonte Kendrick's motion for mistrial. All right, so this is a motion for mistrial. Comes down to DeMonte Kendrick, petitioner, by and through his undersigned counsel, and brings this supplement to motion for mistrial, showing as the following: the outside agitator term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider. Professor Dylan Pennyworth of Berkeley. Judge Glanville making outrageous allegations against members of the defense team in the present case. But I think it does in some way outside agitators and everybody else who I think are trying to influence. Okay. Yeah, that's what he's talking about. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to the 14th Amendment due process violation, relating to, in part, to Chief Judge Glanville's wrongful coercion of Copeland to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights. I do want to stop here. It was right. I think the ex parte was okay. Is what they were talking about is a problem. Yesterday, after court, Kendrick received a rough transcript, Exhibit A, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th. The rough transcript was helpfully provided by the court to defense counsel. A reading of the rough transcript highlights that which has been obvious to all observers, except for Mr. Kendrick's counsel. For the past 19 months, Judge Glanville has been willfully biased and acting as a member of the prosecution team, since the inception of this case. I can definitely see that he's counseling them. I don't know if this is the slam dunk. I think previous ex parte meeting was a much more example, was a greater example of him working with the prosecution. But here, I can kind of see what he's saying. Kendrick's counsel takes no pleasure in alerting this honorable court to this situation, but client obligations require it. Due process requires a fair trial. It's not fair trial when an ex parte meeting Glanville, Love, and Hilton gossip like Yentas. What is Yentas? Over a 13-page transcript about attorney Shard, Melnick, and Steele. Okay, I gotta look up Yenta. What is a Yenta? This probably means a teenage girl, because that's what my daughters sound like sometimes. A woman who is a gossip, a busybody. She acts like a nosy Yenta. Okay, I got you. It is not fair. It is not a fair trial when an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he's not acting in the best interest of his client, Copeland. It is not fair trial when ex parte meeting Glanville, Love, and Hilton attack attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland. Yeah, I mean, I get it. It is not fair trial when an ex parte meeting Love lies to Glanville about an email she received from attorney Melnick. Yeah, that back and forth in that email. It is not fair trial when an ex parte meeting Glanville starts talking about outside agitators, stating my comments today were predicated on there's a lot of stuff that's going on in the background, but it shouldn't have to do with anything with you all's case. It really shouldn't, but I think it does in some way outside agitators. It is not fair trial when an ex parte meeting Glanville, Love, and Love have the following outrageous conversation. But I think it does in some way outside agitators. Love that too. And everybody else who I think are trying to influence. That is absolutely happening. It is not a fair trial when Glanville, Love, and Hilton have the further discussion. There's a lot going on. There's a presence. Yes. That is all I'll say. I mean, but I see it from just being in the courtroom and tracking. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? This case is like an old house that the present honorable judge is tasked with renovating. Every time a piece of plastered up wallpaper is removed, more rot is found hidden underneath. Why do you have to be like an old house, man? Why you gotta call my man an old house, bro? Come on, man. Oh, that's too small, Jason. Rot underneath. No no Herculean effort by the present court can fix the due process violations of the last judge. This house must be torn down. A mistrial should be declared, a retrial barred due to prosecutorial and judicial misconduct that has goaded Mr. Kendrick into this present motion. However, or rather wherever, Mr. Kendrick respectfully continues his request that this honorable court declares a mistrial based on at least due process violations of Kendrick's constitutional rights under the federal constitution and the constitution of the state of Georgia on this day, July 31st. Wow. We are back, ladies and gentlemen. It is Shots Fired Tuesday. Oh, Wednesday, sorry. Shots Fired Wednesday. Yeah, this one's going to be a mess. That wasn't bad, though. I appreciate that. That was a very quick read, and hopefully you enjoyed that. Let's get back and make sure we can, we're ready when court is back in session. Give me 1 second. All right, so we got that ready. We're ready, Freddie. We are ready. But we got about 30 minutes, give or take. You said, of course, due back in 5 minutes? Oh, really? Well, we're ready. We're ready then. It says 11 on the screen now. It says 11. So I'm gonna go with my sister from another mister. She seems to be really serious about this. Yes, as the peach rods. I need to drop that. I need a new one for that. Oh, it's all good, retire. It's all good in the hood. Yeah, this is pretty wild. But oh, by the way, thank you so much to Miss Mandy, gifting a membership out there, helping the people. Thank you so much. You just catching up, Becky? No problem. No problem. There really was no work to do, so Judge Whitaker sent everybody to their corners to go do some work so that they can come back, and she had to go read some cases or some motions, please forgive me. And so that is it. Yo, this ex parte thing is crazy that they keep popping up with, oh yeah, well, yeah, I had another one. That is so unfortunate. Because whatever they could have done is just being derailed every time they do this. Okay, let's try something. Let me drop her comment out of the way. Thank you so very much. Oh yeah, please, if you received the gift, please make sure you say thank you to Lady Mandy. The names must be named, as a friend said. The names must be named. All right, let me see. I'm going to. Yeah, that would be wild if Melnick shows up. All right, let me try this real quick, make sure this works. I'm going to bring in As the Peach Rots. Let's go.
Welcome back to Season 4 of As the Peach Rots. In this suspenseful 4th season, we marinate the feeder of Georgia's political elite in the tangy vinegar of accountability. In a state where the odor of mendacity toxifies the air, our perspicacious team of chatroom investigators is on a mission to peel back the layers of deceit and uncover the truth. From backroom deals to embezzlement scandals, no stone is left unturned in our pursuit of justice. But as tensions rise and alliances shift, who can be trusted in the Peach State? Join us for a season ripe with virality, where even the fruit isn't safe from corruption, because sometimes the juiciest scandals are right under your nose.
That worked out pretty well. Okay, cool. I'm glad I got that to work. That was pretty cool. I like it. I'm glad that worked out. Let's see what we got. Good to see you, Lady Bonner. Good to see you. Barry Tucker, please forgive me. Good to see you. They do seem unprepared. It's almost like they're getting like, oh, we didn't expect this to happen. We didn't expect it. Maybe they didn't expect to work. Maybe they thought it was just going to be a lot of horse trading all week, and they didn't think they were actually have to be held accountable and expected to be able to, clear that evidence list or um, clear their pare down their witness list. Maybe they didn't think that was going to happen. Good to see you. Thank you so much, Barry Tucker. All right, everybody, real quick. I'm gonna hold tight. I'm gonna jump out just for a second. I'm gonna pull this up just in case it pops up while I'm gone. All right, everybody, grace and peace. They should be getting ready to come back on in a moment. I just want to make sure I at least chatted with you all. I need your help. I need your help with something. It's a serious request. I need you all to help me out because I am the father of a daughter who can drive. So I'm walking around this house looking for my kids. And lo and behold, these jive turkeys have left and they've already gone over to the school, and both of them. So they just get in the car and go now. Y'all pray for your boy. I'm sitting right here running around the house like, hey, where y'all at? Hey, well, I knew President Firstborn was going. I didn't realize Secondborn was going with her. That's craziness. So now, smart guy, I go and look, and I'm look on the app, and they're over at the school. Amazing. Amazing. Anyway, I'm over here looking for these rascals, and they got, look, she a woman on a mission now, man. She just go places. Yesterday I asked her, I said, so tell me where all you went. Because she went to go get her hair done. Both of them went to go get their hairs done. Did braids to start the new year, the new school year. I said, that's cool. So went and got their hair done. She said, yeah, then I went here and I stopped there and this, that, and the other. Like, yo, she's just going everywhere. It's craziness. So oh, definitely. Oh my goodness. Yes, they are planning their next assault on the Citadel. My goodness, in the morning. Yes. If they're not, I'd be surprised. I'd be let down. Let me say that. All right, let's keep this going. Let's keep this going. Doug, yeah, Doug was a little bit livid. He brought some heat this morning. He was upset for sure. Absolutely. Bald head matters. Bald heads matter. Come on. Not only am I the president of the Bald Head Club, I am its founder. Absolutely. I personally, Robin, I think you hit this nail square on the head. The second sentence is hands down. When you have the ref working with and in conjunction with the prosecution, because nobody's saying that the judge was working on the defense team. It is very clear that Glanville is working on behalf of, and even in ex parte, he's literally talking to them as if he was a teammate. I'm sorry. How have you all added everybody? Y'all got YSL Weinstein now. There's a YSL Weinstein. Is Matthews in there? Is YSL Matthews? Is he one? Y'all wild, man. Y'all are wild. But what I do know is that she's gonna be back on time. That's what I know. She's gonna be on time early. On time or early. Please forgive me. All right. Hey, I put up a poll because I have to go over to the school at oh man. Okay, so when I go over to the school, I'm just gonna leave the live stream up and you all can keep conversing and doing all that kind of good stuff. And I will if I can get back earlier, I will before they end, I'll jump back in. If not, I will try my best but I will be back tonight at 7 o'clock anyway. So there's that. Thank y'all so much. Let me, matter of fact, make sure the moderators have been alerted that they have all the powers now. Mm-hmm. All right, we're gonna get that. Every time you do this, you gotta peg your little thumbnail, fingerprint. There we go. All right. But hopefully you all are enjoying this, man. Today was much better than yesterday. The energy level of the various and sundry was way better than what we saw yesterday. So I think that's only a sign of good things to come. But I do think that Judge Whitaker is trying her best. Again, whether I agree with it or not, I do think she's trying her best to keep this thing, to get this car back on the road. And I don't like it, but I think the analogy is good, that she's trying to fix the flat tire while she's driving the car, and the blown out tire while the car is still moving. I think most of us agree, pull the car over to the side and fix the problem, because maybe it might be something worse than what you think. Hold on one second. Yeah. There we go. All right, we're fixing these things up. We're making them right. We're making them tight. I love it. I love it. All right. Kiana, if you could check your email real quick, that'd be great. I'll text you as well. Sorry about that. All right. All right. Judge needs some sun. Way too pale for a Southern girl. Oh, come on. Now, I wouldn't talk about it like that. I wouldn't talk about it like that at all. But I understand your point. Do not, hey, I would not be surprised if there's some written mandamus already on his, he's already got it saved in his notes. Like, I wonder, how do they file those things? Could they do that? Could they literally have like motions already filed on their phone, and as soon as you say something dumb, motion file? Like, is that how it works? That would be funny. And actually, I'm sure it probably is. Save it as a draft, and as soon as you act up, I jump on my phone, I jump on my computer, filed. They're gonna get back just in time for lunch. I think they're gonna have about an hour. They're probably gonna work for about an hour and a half. So probably like 12:30. That's what I'm betting. That's my intimation. That's what I think is gonna happen, but I could be wrong. All right. Clean out some of these. All right. I think we're good to go. Looks good. Looks good. Okay. They are still not there yet. So appreciate y'all. Okay. Hold on, let me. All right, Q, I just sent you another email. Let me know what you think. I do like that show me in case law. There's gonna be some hot takes from this trial for sure. There's gonna be some stingers for sure. There's gonna be some stingers for sure. Okay. Okay, I think the general consensus, I'm gonna leave it up for a few seconds, but I think I'll just leave the live stream up when I run over here to the school. Okay. Yeah. Oh, they got movement. I see movement. They crack me up with this, man. They are so funny. I see some heads moving. Look, she done already whipped them into shape. She said, look, y'all gonna be on time. There we go. Thank you, Q. Appreciate you. Got it. Cool. Thank you, friend. Thank you so much. Let me see. Looks like some good comment. A lot of attorneys. Let's see what Laura says. A lot of attorneys whose clients were convicted in trials with Glanville, Hilton, and Love involved are watching closely now that they're showing that they support a lot of their arguments without Georgia law. Wow, you're good point. Very good point. But they should have called that out in. Yeah, I think they should have, and I could be wrong because I'm not arguing from Georgia law. I'm just arguing from my mind. I would think they should have called that out in real time in 4K. That's what I'm thinking they should have done, but I could be wrong. I hope that made sense. That's a great call, though. I like it. I like the show me in Georgia law and case law. I like that. And hopefully that's, if this case were to continue on, hopefully that's going to be the way she, that's going to be the flavor of how she deals with all this, because I think that's a great way to handle it. Y'all, why am I over here looking at a hat? Somebody sent me a link for another hat. I do not need to buy any more hats. Yeah, like my daughter walked in this morning like, Dad, you got more hooks for hats. That's crazy. I don't need any more hats. I don't think I do, though. Maybe I do. There's no reason, Jason. Log out of this site. Do not get another hat, Jason. All right, I'm logging out. Don't worry, y'all. I listened. I'm logging out, I think. Okay, I logged out. So that's another good question. Okay, something with the 19th of August. I don't know what was going on then. It was supposed to be off that whole week. I don't know. This was already scheduled even back with Glanville. I have no idea what that was about. So I'll have to look into that. So they were supposed to be off that first week in August. I'm sorry, the week of August 19th, and I don't know why. So yeah, that's a good catch though. The jury's about to be off for the rest of they're about to be dismissed. Now, and I don't know if the jurors have to be called back in to be dismissed. Judge Whitaker just says today, you know what? This is crazy. I'm done with this. Do they just never have to come back or what? I don't know. Come get your last paycheck. I don't know. Clean out your desk. Wow, they ain't playing. They're back.
Grounds to, would that still be considered a prior inconsistent statement? And Your Honor, I have three cases for the court.
Okay.
I have Green v. State. I have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Sconyers v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS v. State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It is an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes, thank you.
Oh, sorry, and I'll give it to you. Give me 1 second.
Thank you.
I gave you green already, Mr. Long. I gave you green already? Which one did I give you? Thank you, you're welcome. You're welcome.
I know it's petty, but I want that camera angle that they have right there, those four. I want that. I want to be able to see that. I want to see that,
All right,
that
so
four
Green
camera angle.
seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the one I've looked at so far, is there one that says, if you say, yeah, that was a total loss?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officers interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said, a witness's failure to remember making
All right, so hang on. You're talking too fast for the court reporter to take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
And when the court the analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia 63 at 66, pages 66 through 67. They further cite Bridgewater, which is 309 Georgia at Penn site 887, which cite a defendant's denied recollection of making a statement provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Scaniers that discusses primarily that the state does not now have to go through every single inconsistency.
Okay.
But that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further details. That's kind of our summation of Scaniers.
All right.
And then Odom, Your Honor, is a federal case on the same point as the Green case, Your Honor.
Right, thank you. Appreciate it. Counter law, counter position from any of the defense attorneys?
Your Honor, I'm gonna let
someone that's better than me respond, like Max Sharp or someone. But I just want to state that the foundational element for this argument doesn't even exist, because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't, because we...
Right. No, I mean, I don't think anybody disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue, given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true. Yes, he may get up there. Who knows what he's going to say? But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was, according to y'all, and I've seen some of it, that was a complete lie, then we will face this. And so let's figure out what
So we're guessing at what he may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely.
Thank you.
Okay.
And if for anything, I do remember that there were at least 2 full days of testimony from the 10th to the 12th. And it's the state's remembrance that the I lied started early in his testimony. So, but we can.
Thank you.
Deal with that as well.
And with regard to that, the court reporter has said that she probably, what did she say, Ms. Hurstfield? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said by either late today or tomorrow morning, she should have, I believe it's June 10th. June 11th, and then would be working on June 12th, shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th, 11th, and all of the 12th.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked 3 questions and that.
All right. So do we already have the 10th somewhere? We'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Your Honor, I don't think that the state's cases, from what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case, it is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember, reading right from the case, he says, Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, "I'd be getting high, I don't know." After a break, Milton testified that he did remember telling law enforcement, quote, "lies to try to get out of trouble," unquote, and that he would, quote, "say anything," unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said 23, I meant prior inconsistent statement.
Okay.
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or
Right.
testimony by contradiction. So I found this case, if you don't mind pulling up, or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. And that is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that the particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. Then it says, however, the fact that the witness admits that he or she made the prior inconsistent pre-trial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, it's I don't want to mislead the court, it's under the former 24-9-83. Then I looked at Cummings, which is cited, which is Cummings versus State, which is 280 Georgia, 831. It's in Division 3. It's a 2000. Now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division 3.
Yeah, so it looks like in that case, he just refuses to answer whatsoever.
Exactly, which is really obviously, saying I don't remember, I don't recall, I don't, I may have said something. Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to argue with it. But then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green. Green controls, and if whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Yes.
Thank you.
All right. Thank you. Thank you, Ms. Hilton. That was a helpful use of our break. All right, so with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the states as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
Or it was what was hashed out during
the state of it. Okay, so were those hashings out done prior to or after the recusal motion being filed?
It was done, 3 of them were definitely done after the recusal motion was filed.
Okay. Well, the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the other, I know we were in the middle of playing 2 of them.
Oh my
during
gosh, no
that
more
time period.
no more videos,
confirm when we
please.
actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. I believe we played those interviews on Monday, June 17th.
And which would be part of what either needs to get redone or y'all need to make a,
Yes,
come to agreement on.
and we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have any issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So,
All right, I'm not sure I follow you.
Okay.
So what you say you want to revisit. So I think first it would be helpful to know which ones were hashed out before the recusal motion, and then we can just say that's what we're going with because that was prior to any issue, and therefore we can stay with that. As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So have y'all had discussions yet about, I thought y'all wanted to figure out what was actually done and what wasn't.
and I guess maybe I misinterpreted what I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't
I just
any
posted
that
a
were
poll
done
for you
that we
all.
wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection to the current state of the redactions based upon what occurred.
All right.
And so that's what I thought I understood.
Okay, and that was January 11th, January 28th.
February 20th and February 21st.
And so you will let me know which one or ones of those were hashed out before And that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided. And if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody. Yeah. Is that true?
No, we did hash out that one as well.
Oh, you
want
want to revisit that one?
Yes, Your Honor.
Okay.
Oh, you just want to do your own thing.
Okay. All right. Can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations made as to any of those?
And respectfully, and I'm not trying to belabor the point, but I just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post serving the recusal motion at this time.
Okay.
So
well,
that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th, and the 25th, and the 26th.
Yes.
Okay. Which is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations where we agreed and didn't agree at the time.
Okay.
So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Another work day. See, wow. I'm sorry.
I'm sorry I don't have a better answer for you.
Okay.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Short just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Short is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah. So
when I met with y'all, when was that?
ask for time
Friday,
is bad
a week
luck.
and a half ago. And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so to before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this, because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other, it wasn't that long ago. So.
Seems like it was.
Okay. All right. So how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Mr. Zachary.
They shot that down yesterday, though.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over, well, we have turned over the statements that Mr. Zachary has made.
All right.
The belief that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful and consistent, but we don't know what he's gonna do.
Okay. So for a whole lot of this, I mean, y'all can't really, let's assume that he testifies. Let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, well, let me look at all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a contingent ruling, but if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
And with the court, is the court asking for a copy of each of his statements? Because we can't provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7 lines, whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then of course, if in court, I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary?
The state's case is such a hodgepodge. I don't think they ever expected this. I don't think they expected.
Does
no.
everybody have Mr. Zachary's statements?
Yes.
Okay.
That's fine. All right, I'll take the hit here.
I still don't think it's the,
They do
the
keep sending you up here to
defense's
be the one.
responsibility.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy
But y'all are all old like me and you like paper.
and because we have our notes on the paper too. And so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today. So
Yeah.
I didn't bring the transcripts with all my
Yeah,
notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but
Understood.
okay, yeah, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of
Okay.
talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and other witnesses that you're going to be getting to soon?
We have been, not entirely winnowed, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
This is crazy. This is so
I
disappointing.
mean, Mr. Zachary is a witness, right?
But I don't believe that we have any jail calls from Quindary Zachary.
No, I was just using that as an example of winnowing. I'm not asking about jail calls from Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it.
Gosh.
So you can say, here's the portions we think we want to use. And then they can say, only look at those. Here are the objections we have.
Yes, I can do that. I have not broken it apart.
Okay.
Segment scientific.
Okay.
As I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
No witnesses.
And so if,
We're done.
I'm trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What we can do as a prosecution team over the next however amount of time the court wishes to allow us is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify just to the court and the defense, those people.
What in the world is that?
And looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
But that's not the
I
defense's
like what I'm
fault.
hearing there, that by the end of today, she have done that for all of them. Yes, I like that.
They're not gonna do. They're not gonna do that.
You did say it.
No, I don't know. But I not know the shot.
Well, what's up with that
Might have
microphone?
overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything right now?
Isn't it the state's responsibility though?
Not anything.
It's
What?
not anything we can go forward with, but Judge Glanville had given me, on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801 D2E issues, co-conspirator statements
Right.
issues. The court indicated that, well, it required the state to provide to the defense all of the 801 D2E statements that the state contended it would seek to admit
Okay.
during the course of the trial.
Okay.
That notice was filed on or about by the state on or about, excuse me, November 3rd
Okay.
of last
23.
year,
Okay.
obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same. They only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out. A year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay. Understood.
So I want to get that on the record.
Right.
And finally, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever
Right.
that I want to reallege and reaffirm.
And Mr. Nichols is charged with count one, the gang count.
Yes, that's correct.
Okay.
Better
Do
than
you
proving his
want
gang.
to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that I know that all 6 of the defendants here are charged in count one, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, other than the RICO count, This doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you
Okay.
with that, whether you ultimately do that or not. I mean,
Yeah,
this
I mean,
is
I
what
don't know.
we've
I'll
been
hear from
arguing.
both sides. But
Yeah, it's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right, so we'll get you that
Okay.
as soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. But does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice of 2022.
2022?
We provided 2 801 D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes.
Okay,
Yes.
and then you're saying there's another one?
Yes, that's November, that was filed on November 30th of 2022.
Okay. And give me a second, Laura.
Thank you, Judge. In the 2022 notice, we stated that the state will establish the ongoing conspiracy of the YSL Criminal Street Gang Act trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial, or in the presence of a defendant currently on trial, that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What
Turn your microphone on,
notice
Sister.
does the defense have of specific statements that are not included in the November 3rd, 2023 notice?
Okay.
Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide.
Sorry, when you say in this particular notice, which notice?
The November 6th, 2023 notice.
Okay. November 6th. November 3rd?
It's just, he said it wrong.
It's filed.
November, okay. You provided notice of 3 different statements.
Right, 3
right?
specific ones.
Okay,
Yes.
right?
Yes.
All right, so my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are, just one moment.
All right.
And so that we are clear, because there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right. I have yet to find the notice that y'all are talking about.
The
Throw
November
this
6th
case
one?
out.
We can
Yeah,
send it to
because
the
y'all,
court.
there are a lot of filings
We can
in
send
this
it to the
case.
court.
But Ms. Persifield has saved it for me somewhere, but there are already a lot of things in our file also. So,
We'll send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it? Just emailing it to me because I need lots of assistance. Thank you, Laura.
Q, what you talking about? What am I lying about, Q? What I do? What I lie about, Q? Tell me what I did. Tell me, set me straight. This is ridiculous. What does a state have ready to, if the judge said you have to start right now, what would they be able to do? It's not on the defense
And so
to
was
know.
there
I mean,
an order at some point or a direction
This is
from
wild.
the judge to tell the defense which statements she believed to be co-conspirator statements that led to this supplement?
Yes.
Yes. Okay.
I'm looking for.
Okay. I mean, if there was, that's all I need to know. So yes. So, okay. Now tell me what other statements you believe to be co-conspirator statements and why they should come in now when
Right,
you
like-
were ordered many, many months ago to tell the defense what they were.
how is a jury supposed to make heads or tails of this?
As part of the jail calls and the wiretap.
Okay. So they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement. We intend to use it.
Yes.
Okay. Well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands
Yeah.
of jail calls involving dozens of people.
Yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators, why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now?
Yeah, one second, I'm reviewing.
Okay.
Okay, I got a really crazy
Give me
idea.
1 second.
What if Judge Whitaker?
But
Okay.
yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
What if Judge Whitaker is allowing them to show just how unprepared they are, and she's going to roll up and say mistrial?
And so that the court knows what I'm doing, I overheated. And so I had to.
By which you mean your laptop overheat.
I do mean my laptop.
Oh my gosh.
Because I've told y'all not to overheat anymore.
So that's what's
Okay.
happening.
Okay, the Judge Whitaker has a lot of jokes. This wit
Yes,
has
sir.
a lot of jokes.
While she's waiting for that.
Sure.
Could I just briefly address a side issue?
Sure.
When we met for the status conference, I
Yes.
believe Mr. Harvey asked you if you would support us when other
Yes,
judges try to
I
drag
recall
us in.
that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, "Oh, I'd like Mr. Harvey for trial." And I said, "No, you can't have him." So
Thank you so much.
Yeah,
Your Honor.
mhm.
But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that. So you were referencing that week last week where we were out and why we weren't working to prepare
right,
for this.
right.
I was being called into court all over the state of Georgia,
Sure, I
just because,
imagine.
and maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation
Yeah.
to do for this week,
Uh-huh.
but unfortunately, I was hauled over all over the state.
Right.
I'm
And
sure
we didn't really talk about that.
Yeah, are you going to cover us for that as well so that we can work on this trial during those breaks?
Because, I mean, we may just have to decide that on a break by break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, why don't we take that up kind of as we need to?
Okay.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or take Friday mornings for motions and Friday afternoons off, or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for myself.
I mean, let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer right
Okay,
now.
thank you.
All right.
Okay, so crazy idea. As I said before, I'm wondering if Judge Whitaker is just to prove that these people are not prepared. But I think we all now agree. Drop a 1 in the chat if you don't think that the state is prepared. Maybe that's it. Maybe she was just trying to set them in a place where you can see clearly these people are not ready to do this. They're just wasting time. Right, no, I agree. I don't think they've been ready for 103 days at all. What is it? I think the defense should stand up right now and say, we are ready to go. Let's go right now. And they'll go crazy. Love and Hilton
How long
will
are you
short
going to
circuit.
need? 2 minutes, 10 minutes, 1 minute. Okay.
Now, minute. Let's go right now. This is like study hall, man. Like, I would be, man, this is crazy. I love it. I love it. We're a gang now. At this point in the game, we're a gang. And the bad thing is they have as much evidence to prove that we're a gang as they got to prove that YSL is a gang. I mean, that's how prepared they are.
Your Honor, we're going to
Withdraw
allow
charges.
Mr. Atkins to stand up and give to the court the cause that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
One of the wiretaps.
One of the wiretaps.
And Your Honor, this wiretap is a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of I wanted for the defense to know where this specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page on that document. So that's how I'm going to reference it for all parties to speak off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
Ballpark.
She said ballpark it.
5, 20, 100.
What's the house?
More, they will be closer to 50 to 100.
Okay. So instead of standing there and reading them all, do you have them in writing?
I do. With what I can do
Bless
is
his heart.
take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a document that has the date, time, reference number.
I would
and
think that would be
PDF
easier
page.
for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with is Demekion Garlington, who is a severed co-defendant.
Right. Okay.
And I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay.
Okay.
Okay. All right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator. You, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who is also, he has pled guilty, but he was one of the 28 indicted defendants in this.
So you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor. Yes, Your Honor.
All right, Sumlin. And there are You can do the same for him.
Correct.
Okay,
And he
perfect.
has less, it's hard for me to ballpark the.
That's
number
fine.
for him,
I just was like, if it's 2, you can read them out, but if it's some huge chain, then it's easier to just give them in writing.
but- Yes, Your Honor.
Okay, all right. So that is 2 further potential co-conspirators who have statements we will
That's a
need
great
to
question,
litigate.
Miller.
Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay,
That's a part of the 5.
jail calls.
My pleasure. Thank you, Becky.
Portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in?
Bless her heart.
Okay, that was part of the notice, so that
Bless
one's
Sis
good.
Witt's heart.
I don't think it's part of the notice, but
They don't think that was part of the notice, but they're willing for y'all to say that's good.
but there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and, all right, well, y'all have already been litigating that, so I'm gonna call that one good in terms of notice. Whom else?
Why does the state, I'm sorry, why is the defense being asked to come up with something when it's the state that's currently in play? I think this is their unpreparedness. What did they expect to do? This thing was going to go on. I promise you, if Glanville was still here, this thing would have gone
right.
on to
Question.
2027.
So I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay.
Yes.
Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right.
You know, this is somebody's life in the balance. These people are this unprepared to prosecute this person's life, to determine that this man should go to jail.
Can you provide to this judge whatever that
rest of
supplement
their
was
lives.
so that I know?
I agree, Tawanda. This is
Thank
embarrassing.
you.
Just let it go. Y'all have messed this up. This is these dudes' lives. We're not just talking about playing pinochle.
Do y'all, deputies, you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do y'all actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
Quick question.
Yep.
I can't, I'm having a hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to the judge. I can't find that.
Okay.
I'll look for that. I'll look for that.
During
No.
lunch.
Our reference where it said that you can't use.
Okay.
Matter of.
That'll be great.
Thank you.
Thank you.
I'm sorry. Love is overstepping her
we're
bounds
recessed.
again.
Let's say till 1:20 since we've already eaten up like 5 minutes.
That was a minute. Okay, I'm sorry. I disagree with Sis Witt right here.
And Your Honor, are we looking for, I
My lips
apologize.
are moving. What you talking about? What you talking about? What you talking about, Laura? Hopefully I'm okay.
All of them, when the court had asked me earlier.
Oh no, they're back. They're literally
whether
back.
In all of the jail calls, all of the wiretaps, all of the recordings.
Yes, at this stage of the game, we need to give notice to the defense of every potential co-conspirator statement. And if in the afternoon you can do essentially what Mr. Atkins just did, it's going to be this set of statements. and we'll give you the details of where to find it later. That's fine. But yeah, it's going to be this witness, that witness, and the other witness in these statements as to each of them. Yes, because A, they need to know at this point, and B, we need to know what we need to litigate at this point. So yes, thank you. All right, in recess.
All right, sorry about that. Apparently my monitor froze. All right, I'm sorry. This is a dumpster fire. I don't know how they're going to salvage this at all. And I know Judge Whitaker has got to be looking at, look at how unprofessional this is, how unprofessional they are. She's got to be worried about this. Anyway, I thank y'all so much. Okay, I'm going to leave the stream up. I do have to go to my daughter's school though. And the such like that. I'm going to try to get back. And I don't know what happened, why my monitor was frozen. I don't know what happened there. But y'all get in this chat and give them the business. I'm handing it over to Wanda. Hear me. At this point in the game, I think I'm a co-conspirator. I'm a co-conspirator. We already got DWC is a gang. We've already concluded that we're a gang now. And I don't understand. I have no idea how she's going to get this thing back back on track. Yeah, we're a gang at this point. So you're a part of a gang. So you're confused. Don't worry. You are in good hands. You are in good company, rather. I don't get it. So if I don't make it back before they're over today, the stream will end. And I will be coming back tonight at 7:00. I have a couple of guests coming in. We're going to be talking about this case. So bring your questions, all that kind of good jazz like that. I believe it's already been posted. Let me just double check that the live stream for tonight has been posted and it's good to go. Yep. It's the recap show. Yep. It is ready it's there. So definitely jump back in tonight if you got some more ideas, or who knows, maybe something fireworks will really be set off after lunch. And you're a co-conspirator. There you go. I don't, yeah, that's gonna have to be it. We have to say the gang's all here because I think we're a gang at this point. I am completely flabbergasted. What did the state plan to do? What did they do for the last 10 days? That has to be a question. I'm gonna text my sister, Siswit, and say, what were they doing for the last 10 days? And now, what did they think they were gonna do this week? I think they were hanging too much of their weight on Woody. And I think they lost it. They were like, whoa. When she said, well, can we move past Mr. Copeland to the next witness? I don't think they were expecting that. I don't think they were expecting to move past Woody. I think they planned to sit there and go through those interrogation videos and all that horse trading that was going on with those interrogation videos. I think they expected to just pick back up with that craziness. That's the only thing that makes sense. I don't think they planned to go to whoever was Mr. Riley or whoever the next witness was. I don't think they expected her to do that. And yeah, I have no idea what that is. Craziness. So I want to hear what y'all were saying about it. So I'll definitely, when I get back, I'll definitely make sure I read the chat. Feel free to jump in and comment, go get you some lunch, all that kind of stuff. I am going to pull the screen back up so that it is here. And then y'all just give them the business, man. Man, this is craziness. It's embarrassing. I'm like, this can't be the best that Georgia has offered. It can't be. It can't be. So everybody, thank you so much. I appreciate you. I'm going to leave this up and I will see you all. Hopefully I'll be back before the stream is over, but I'll definitely be back at 7:00. I'll see you all soon. Grace and peace, everyone.
Hey guys, he is running a little behind, but I'm going to start the trial up for you guys, okay?
Identified within there?
That is my.
Okay. Is the jail call subsequent to the time that you provided the notice?
No, the jail call date is 2015. It's in 2015.
Okay, so is there a reason you didn't include the jail call in the notice that you provided?
Okay.
When we were preparing the notice, our understanding of the need to extract jail calls that contain this information or wiretap calls that contain this information and identify them was separate from our obligations regarding generally what co-conspirators say.
Okay. Can somebody provide me either the order, oral or written, or the directive that the court gave to the state so that I can figure out whether that was a reasonable interpretation?
And we're going to
Okay.
do that for you. And at the time that we were under the obligation to present the co-conspirator statements, we were still, and the court was aware, we were still listening to, because there was an ongoing commentary about the jail calls and the number of them and identifying them. So we were still listening to
Okay.
them.
So at some point, presumably you completed your listening. I mean, I know they're still ongoing, so I'm not talking about a jail call somebody did last night. But
even
okay.
all of the ones.
Do you understand? I'm sorry to interrupt you, but let me back up and ask a different question instead. Did you understand that you had a continuing obligation to notify of co-conspirator statements, even if it didn't include jail calls and wiretaps?
Yes.
Okay. And with regard to whether there was some other understanding about jail calls and wiretaps, I'll sort that out later. Let's, at this point, are there other people who you think are co-conspirators, who you think you have co-conspirator statements for that you are potentially going to want to admit in this trial? And let me direct your attention to, because this might help you a little bit. You, a couple of days ago, provided at the court's request to the court, and I assume to opposing counsel, a kind of modified list of witnesses still to go. All right. And you have at least a broad outline of evidence you expect with those witnesses. And some of these people you have actually identified specifically as co-conspirators. So, I mean, can we go through that and at least with regard to those people, see whether, yes, in fact, there is potentially such a piece of evidence? All right. So if everybody wants to follow along and pull out your state's witness list, the first one that I notice is number 3, Antonio Sledge, who you say is a co-conspirator, and then on your evidence you have listed a defendant interview and a jail call. Right. Could that potentially be?
Yes.
Okay.
Yes.
So we can add Sledge to the list. Then Zachary, you mentioned, so he's already on our list. Now, some of these I just don't know, but there are a lot of them that have interview or something like that over to the side. I mean, somebody like number 7, Kenya Morton. I don't think she's a co-conspirator, but okay. And then Arnold, who's number 27, you mentioned. How about number 35, Wooney Lee, who you have labeled as a co-conspirator?
He is.
Okay, and are there potentially co-conspirator statements from him?
You for 4 months.
So unless, what we have of Winnie Lee consists of social media
Yeah.
evidence. So arguably, if that could be considered co-conspirator statements.
Say better to say yes, I think so, and it not be than the other way around at this point. I think it was 35, 33. Says 35. Oh, no, it says 35 on mine because I got what, today maybe? Or yesterday afternoon, an amended witness list that adds a few people.
And Your Honor, for the record, it added 2 custodian records for
Okay.
Sprint and T-Mobile.
Okay, so anyway, Winnie Lee, either number 33 or 35. How about, and you mentioned someone earlier this morning, and someone y'all already had notice of from November of 2023. So someone's, okay. I mean, that may be it in terms of, in my review over lunch, what I noticed to be pretty obvious ones. Are there other ones?
Yes, I'm on mute, or I was on mute. But he's not here yet. He's picking up his daughter.
And Your Honor, I think I took it for granted, but all of the 6 co-defendants currently on trial, their statements, their social media, and the jail calls that they have, that we have of them.
Okay.
Would be
All right.
considered co-conspirator.
All right, and I think that with regard to the 6 co-defendants on trial, it is, I mean, pretty obvious considering that there's a RICO count as well, that the state considers those people to be co-conspirators of each other. It still might be helpful to identify the statements, but with regard to deficiency of notices to those people, I'm going to say that's okay, that's kind of Within the context of there being a RICO count against them all, that notifies the defense that at least you think they're all co-conspirators. So if you can identify the statements as well. So that leaves, I guess, so does that mean that there are no others other than the ones we've run through just now?
I want to say that that is accurate. I want to be accurate before I say that that is accurate.
So while she's making sure she's being accurate now, somebody else can tell me, so on the notice that is from November 2023, the two people who are they? Zachary and Sumlin, the people that are identified as like person A and person B? Everybody seems to know except me at this point. I mean, y'all know at this point. So how about somebody on the defense side tell me, and you don't even have to say who's who, just. Ms. Weinstein, you're looking at me like I know, but.
This seems like a job for Max Sharp.
Apparently it is, because here he comes.
I'm looking at, am I correct that you're asking about this notice of the three?
Yeah, there's a I don't know what it says, witness A and witness B, or person A and person B. And then y'all said, or she said, there was a supplement that actually identified who those people were. So.
So, Your Honor, witness A was Mr. Copeland, and in that notice, we
okay.
talk about the statements that Mr. Garlington made to Mr. Copeland. Witness B was Quindarius Zachary.
Okay. All right.
And he's talking about statements that were made by
all right.
Defendant Stillwell and Defendant Kendrick.
Okay.
And
yes,
I agree with 1 and 2. 3, I'm not sure has played out in actual testimony.
Okay. Do y'all know who 3 is?
I think it says Donovan Thomas Sr. to his brother, but that wasn't co-conspirator.
There's only an A and a B that are like not identified people, right? Okay. Okay.
But 3 is not a co-conspirator statement, correct? Okay. So there's only 2 co-conspirators, alleged co-conspirators.
Okay. All right. So with regard then to
Damone Blaylock, Your Honor, there are statements that are made, well, there's social media that we have identified. Damone Blaylock is a defendant in this case who's been severed.
Severed, okay.
He social media from the incident listed on the indictment that he was already tried for with one of the other defendants currently on trial.
Okay. And Lee is also a severed co-defendant, right?
Lee, yes.
Okay. How about Sledge?
Sledge is a co-defendant that already pled guilty.
Okay. All right. Yes.
You might want to know Mr. Lee, he resolved this case.
Okay. But I mean, he was at one point part of this indictment, the big indictment. Okay. All right. So then really for everybody that was a part of this indictment, everybody was charged under the RICO count, right?
Yes.
Okay. So it will come because this really alleged that in the indictment. So at this point, there is an objection that they don't have notification of what the statements are. And we are several months in. How quickly can you get to them the detail about what you think co-conspirator statements you intend to introduce? Go ahead.
Your Honor, not certain what amount of time the court's willing to allow us to identify anything not already identified or in the indictment. I don't know if a week exceeds what the court is willing to give. It's what we would ask to identify within within the discovery already provided,
Right.
identify specific statements that are there. We would ask for a week to identify that.
All right. Understanding, Mr. Harvey, your objection to delayed notice. I am going to overrule that objection right now to the evidence is. And a part of the basis for me overruling that is that it appears that the whole trial has kind of been operating on a rolling basis with hey, every other Friday, let's talk about the evidence that's coming in for the next 2 weeks. And so if that's been the understanding, then so be it. But I want that to stop right now, which is why we are going through in what I consider to be is spending its time doing. This is what y'all ought to be doing on your own. But I want us to get on a track where the litigants know what is potentially coming in against them, less than here's the universe. And I want us to be efficient, but I don't want y'all, anybody, either side, having to try the case sort of, blind or practically blind. So now that I hope we all are getting a better understanding of how it ought to work moving forward, I am going to give y'all, because I've given y'all a lot of other tasks as well, 1 week until next Thursday to get all of that in detail, including anything in wiretaps, including anything in jail calls to the defense. Okay. You look like you want to say something, Mr. Steele. Okay. All right, you're welcome. Okay. So, what else can we get done today?
Just to address a matter that the court asked me about before lunch. The court had asked when I represented that my understanding, if I'm not mistaken, was that the matter of disqualification of a judge was not competent evidence to be used in the trial. I think I said
Yes.
something akin to that.
Yeah, and you said you had some kind of law that
Yeah,
you could
what-
provide to us.
What
Yes.
what I referred to was Georgia Uniform Superior Court Rule 25.6 and my understanding of it.
Okay.
If it's different than the courts, then that's not unusual. But the last two lines of the rules say that if a motion to recuse is sustained, the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So the way that I understood that, and of course that rule is, cited in other cases, for instance, not for the proposition that the disqualification is not competent evidence. It's just cited in a block cite in Evans versus Williams, 341 Georgia App 226. But that's my understanding. If my understanding is not in line with what the court's understanding is, we would have other arguments against the idea that somehow the recusal of the former trial judge is competent evidence and in some way relevant to whether or not the defendants did or did not do what they are alleged to have done.
Well, it's not relevant evidence as to whether the defendants did or did not do what they're alleged to have done. It cannot in any way be evidence of that.
I mean, I was as to relevance. That was
Okay.
why I was saying.
All right. So relevance.
Hey, we
will
watch you
be,
too.
a separate issue from whether it is, and I can already anticipate the argument because I would make this argument. What you just read says any other case or proceedings. What does that mean for the case that it happens in? So I think we probably need a little bit more research.
And that is what I sought
Okay.
to do over the lunch hour, but I did not find any Georgia case law that
Okay.
elaborated on, I didn't find any case law that elaborated on
Okay.
that. And so that was,
All right.
that was where I stood.
Okay. Well, thanks for letting us know what it is you were referencing, and I'm not sure if it actually answers our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that. Either competency wise or relevance wise, although I think I pretty fully understand the defense argument on it, but okay, thank you. So I know we're not quite ready on the Copeland evidence. I think we have sent out some of the transcripts we've got already. So we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of? Yeah.
I'm a little confused.
It's not even showing that I have a message, but okay. So that's a problem. Yes.
So regarding Zachary, when we're talking about the co-conspirator statements, we've been talking about Mr. Quindary Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements.
Right.
And we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught Nut down bad. And then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught Nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that two defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay,
and
so the answer is no, it's not just those two.
right. It's the whole state.
No, it's not just those two.
Right.
It's
Well,
all-
something-
And so,
my understanding is the state is saying, and I don't know if this is true or not, but that Mr. Zachary's taking the stand. So that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking the stand. I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those two statements,
okay.
which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance. But I don't know. I can't answer the other statements that I have not been identified specifically.
The statement, the statements that Quindarius Zachary gave to the police, I'm certain everyone is aware within those statements contains statements made by other people within YSL. When he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL. He may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quindarius Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete set of information that they have noticed that we are using that.
All right. So I think I hear you saying that with regard to anybody named with at least one count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
If it is contained within an interview that we have given to them,
Okay.
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement
Not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, we're on trial. So
Right, but they're co-indictees.
Yes.
So I was talking about people other than the co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To the extent that we have given them that interview, yes.
All right, and so are you seeking to say, and maybe this is where Mr. Shard is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements,
No,
or are you going to break it down further within the next week?
we will break it down further, but there are only, I think, the people who've pled, and Quindarius Zachary and Kenneth Copeland, who were not indicted, that
Okay.
fall up under that umbrella.
Does that answer at all your question?
Can I explain how it really doesn't, and it's kind of to move from the theoretical,
Yep.
the theoretical to the reality.
Yep.
The reality is these statements. For instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in the room with Mr. Zachary and his attorney. The district attorney, you're really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house.
Mhm.
And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of it. The shooting of the convenience store on Cleveland, I'm just making this up,
Yeah,
Cleveland
sure.
Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding. And there's no real. These aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him,
Right. So
and
you
everything
need
else.
to know in more detail.
Who
Is
the
the
source
state,
is.
is the state planning to use, I think Shannon did that.
Right.
Is that
and
what you want to know, so that we can then drill down on, is there any basis for that coming in?
Right. I
Is
need
that
to
what
know
you mean?
what the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that
Yeah,
he's saying the
okay.
source is Mr.
Okay.
Huey, but there's just so much information that's just
Okay.
like being thrown out
Okay.
with no declarant, no identified declarant.
Sure. Okay. So first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source. If it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay. All right. So what else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good. So I don't have an agenda anymore. My agenda got hijacked. What else can we do that's productive today? Anybody have any ideas? Mr. Steele. Okay.
I could get you brief very fast, but I argued this before the recused judge and it was denied. The former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost. and then the Supreme Court of Georgia denied cert.
Okay,
But there's a ruling on it.
okay.
So if you don't want to rehash it.
I don't even know what you're gonna ask about.
The indictment is fatally defective.
Okay,
So I could take a quick count, if you don't mind, right now, and it should apply to,
okay.
definitely applies to Mr.
All
Williams.
right, I don't know, I mean, if it is something right offhand, if it. Go ahead.
Okay, well,
Go ahead.
it's a general demur. I was going to do it again at appropriate time, but since you asked.
Since we don't have anything else to do right now. Okay,
So in count 56,
you know what, let me grab my copy of the indictment. Okay, count 56.
I'll get you the page.
Be a minute.
It's page,
Okay, got it. Page 90.
okay, so that charges Mr. Williams, I'm just using this as an example.
Oh,
It
okay.
repeats charges Mr. Williams with participation in criminal street gang activity. And it gives a date range. And it says the essential elements need to be that while occupying a position of organizer, supervisor, or other position of management or leader of the criminal street gang, YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle. Sorry, I apologize, Ms. Winfrey. Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018 and the 8th day of May 2022 while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm and possession of a weapon by a convicted felon contrary to the law. The state, good order, peace, dignity are up. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There
Okay.
are 4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge that gives the essential elements. And that would be pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. that is omitted in numbers 56 and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue,
Okay.
but they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it, and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 US 246 at 252 1952. It's also explained in Elonis, ELONIS versus United States, 575 US 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723.
Okay.
That's 734. It's a 2015 case.
Okay.
It's in Division 2B. And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, Georgia Supreme Court, excuse me, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association because you don't have the right to commit a crime in furtherance of the gang.
Mhm.
That became an essential element. That changed our jury pattern instruction.
Yeah.
And our grand jury did not, in our case, did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks at 24-4-418 kicks in. But I believe that the charges for the gang is not appropriate. I
And
wrote,
did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
they didn't take it
They
up.
didn't take it up,
I
okay.
didn't get under Dukes, DUKES. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never
I
did.
thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and.
Did not, they said it's not a collateral order. I
Okay,
needed a
all right. So they
certificate.
gave you an opinion on the merits of, is this a collateral order thing you can take up?
And
Okay,
then they dismissed the appeal. So there's no
right,
rule of the case.
okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promise that.
Okay,
in those-
and alleged against your client.
well-known courthouse.
Uh-huh.
Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy.
I'll read it. It's pages 1 through 68 of the indictment, but, no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No, I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in that, in
Okay.
count one.
Okay.
RICO conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who are here, also the others who are not here, unlawfully conspired to acquire and maintain directly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is COTMAN versus State, which is 342 Georgia Appeal, 569, it's in Division 2.
Okay.
The 2017 case, that is a teacher from the APS trial. It was also a RICO conspiracy case. The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is McArthur versus Beach, which is BEECH. Haven, which is HAVEN Baptist, BAPTIST Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D, 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit two or more predicate acts. There's also Wiley, which is WYLIE versus Denton, DENTON, which is 323 Georgia Appeal, 161, it's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for a conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, SPACE, Inc. versus Dan Tanners, DANTANNA CNN Center, LLC, and that's at 349. Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it. He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, EUBANKS versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, HEATH. Once the jury's sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that,
Okay.
I mean, intentionally, because jeopardy attached. So.
Sure. Yeah, and if it is already in writing, I'd love to have that. And
I will send it to you.
I assume this got argued at one point before if the
Yes.
prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order
Okay.
and I filed that in a motion that I gave to this honorable court.
Okay.
I'll get the motion, I attached it, but I didn't give you my brief. So with the court's permission, and of course, the state has it already, but I'll
Is it filed in the case somewhere?
appeals. Okay.
And then I'll assume the state filed some sort of a response, maybe not this team right here, but, and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's
No,
worth.
the state argued and then they wrote the proposed order, which was signed by Judge Glanville. So,
Okay.
and it's a long order, it's
Yep.
12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay. Thank you, Your Honor.
Thank you.
I'll get you that brief.
All right, appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date
Okay.
of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was
From-
held on November 20th, 2023.
Okay, thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great, thank you. Appreciate that. All right, Mr. Harvey, you look like you also were maybe going to stand up and come up with something we could do. Oh, and you know what? Hang on, sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you? Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leake, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I could write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for like, I mean, I know like if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about like overnight that is different?
Only for the defendant
Okay.
and the defendant's counsel. That was the whole basis of Perry versus Leak.
All right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
Hazy
close.
memory.
Yeah. Yep.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case, not from within Georgia, but it literally spoke directly to it. So I was at least looking for that. All right. Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's make sure we get it right. So I'll submit whatever you want to submit on that as well. All right. Thank y'all. We're going to take a recess right now. If there's not anything we can do immediately. And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed? Yes, sir. Okay. All right.
So comfort break, everybody. Make sure you hydrate, drink lots of water, get a little snack, get comfortable, because it doesn't look like this is going to end anytime soon. Tell me in the chat, what are you thinking so far about this judge, about love? Oh my gosh, love. And about these defense lawyers. Oh my gosh. Is my mic muted? No wonder nobody was answering me. Do we still think Fonny's going to show up? Just yes or no in the chat. I think that Fonny is not going to let that clout pass her by when she sees an easy opportunity for it. But that's me. What do we think? Yes or no? No. Oh, Corey says. I don't know. That's a free opportunity. No, says we watch YouTube. Oh. Fonny is not coming to dismiss. Hermes says no. Robin says I seriously doubt it. Okay. Well, looks like it's unanimous. Oh, Courtaholic comes in with a yes. Uh-oh. Courtaholic, I think you just like to be different. And that's okay. I kind of agree. I think that that cloud is a little too much to stay away from. She sees that clout goblin dancing in the court, and she's got to go catch it. Got to catch them all. Got to catch them all. You think by the time she gets there, it'll be dismissed? Ooh, that's a good point. That is a good point, Murray's. Good point. And I'm butchering your name, but that's a good point. Doesn't Fonny have to announce or file to appear on the prosecution? I don't know. That's a good point, too. Could she not just show up as a spectator? Of course, they're in a barred courtroom. She can't find it. Can you imagine Ratchet Fonny running her mouth in that courtroom? Yes, I absolutely can imagine that. I absolutely can. She does it because of the office she holds. Does it what? Does it have to announce or file? Is that what you mean? That would make sense. There's no clout left to be seen, nothing positive to be gained by showing up to a game where the team has utterly failed. Good point, retired. Good point. They should be back any minute. All right, I'm going to put y'all on some lo-fi until they come back.
Where's Ms. Bumpus? That's who filed the Rule 22. Good afternoon. All right, so you filed a Rule 22 at, what, 11:10 or so? That's fine. The night before last. So, and you had said that you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now. And so I have provided notice to all of the parties, and I will listen now to, or ask if there is objection from any of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus. All right, so I am not real. So what are you looking to do?
Your Honor, I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's live stream. Miss, what is that person's name?
Miss Sylvia.
Miss Sylvia?
Yeah, she's sitting in the courtroom.
Okay. All right. So there are an inordinate number of separate Rule 22s in this case. Anyway, I'm not really sure why everybody is not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography and audio, and it's just it's a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding. I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and inform the public of what's going on. And that's my point of being here. And I'm just trying to
figure out what's going on. Sorry.
Pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can video blog, vlog, all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time they can say it's copywritten and take it from me. Or from my page.
Have you asked
You guys hear it
any other than
double?
is Sylvia okay with you using her? Because honestly, it's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney in the case, you shouldn't have your phone out or
I'm going to find
on
another feed.
anything,
It's not
and
me. I'm not sure what's going on. I'm sorry.
it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who is authorized to have their phone out, who is not. And so what I would like is until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay. Would that work?
We'll try it out.
Okay, so let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks. All right. Anything else we can do today?
Do you guys hear it double?
Or did I give everybody enough work
but
that y'all can just go home and do your work? And y'all gave me plenty of work to do also. All right, so we are adjourned for the day. How about we see each other at 9 in the morning? Which doesn't mean when we get the jury back. If we get the jury back, I won't go back to 8:45. But let's see each other at 9 in the morning, and let's be ready to actually work on some actual evidence, okay? All right.
I just want to be clear. What is your expectation of the evidence moving if you have
Are we going to be able to, so y'all are getting some of the transcripts of Mr. Copeland's testimony so far. What all have we already shared? No? We don't have any of his testimony? I thought we had at least the 11th. When are we getting that? By the end of the day? That was a really good question, Mr. Sharp. I thought we were going to be doing Mr. Copeland's evidence tomorrow, but maybe not.
Did we ever get an answer, Judge, as to whether or not we have the transcript from the 10th? I know that Ms. Weaver indicated, excuse my seat, Ms. Weaver indicated that she was working on the one for the 11th. She might have it by the end of today is what I heard earlier. But you asked whether we actually had the 10th, and I didn't hear the answer to that.
I think she is done. I think she is done, TT. I think she is done.
What have y'all done? What have y'all done to my sis wit? Y'all done broke her? What happened? She
Where you
calling it
at?
early? What have y'all
I don't see
done?
you.
What have y'all done? What have y'all done to sis wit?
The answer to that is no, we do not yet have the 10th. We had portions of the 10th, but they were the other portions of the 10th. So hopefully by tonight, the court reporter will have both the 10th and the 11th. Y'all should have. Now, this isn't his testimony. This is y'all going through
What have y'all
evidence.
done to
But y'all
her?
should have a rough of the 18th, the 21st, and the 24th already. And then the rest of it will be forthcoming. So I don't know if we can work on Mr. Copeland tomorrow or not. I don't know what can we work on tomorrow?
Mistrial? We can
No
work on
point
mistrial
getting to
tomorrow.
get as much as Y'all are all delightful. No point getting together if we can't get work done.
The 18th, the 20th, what did we say?
The 18th, the 21st, and the 24th. No, so, yes, that. So he testified on the 10th, the 11th, and the 12th, and well, wow, okay. He testified the 10th through the 17th. And then y'all took up matters about the evidence surrounding him the 18th through the 26th.
Too long. That was too long. Didn't even last so long.
All right. I think tomorrow might be more productively spent with everybody working on the things they need to work on. Tomorrow is Thursday, so let's get back together on Friday at 8:45.
Wow.
Okay. See everybody then.
Y'all, this case is hot garbage. Y'all said, Caleb, I didn't see that. I'm sorry. I was rushing to get back in. Y'all, this case is donezo. This case is finished.
Just a quick question for you, Jason.
Hey, what's happening?
And then I'll get out of your way. I can't see anything on my StreamYard. Can you see? Or
Yeah, I'm looking at it right here.
okay. Well, I'm out then.
Oh, I'm sorry. Okay.
All
No, I
right.
can hear you perfectly. Let me see.
All right, great.
Yeah.
Oh, look, everything just magically appeared again. All right, you gotta love StreamYard. All right,
Oh,
thank
okay.
you guys for
No
putting
problem.
up
Thank
with
you,
me.
Mandy.
Bye.
Appreciate y'all. Y'all say thank you to Mandy. Mandy coming in handy. Thank you so much for running the ship while I was out running these streets
Oh.
with the kiddos. I appreciate you. Yo, this case is done. Like, okay, I was thinking about it, and I really truly believe that what she's doing, what Judge Whitaker is doing, is solidifying, cementing, adamantuming, whatever, vibranium. She's trying to make it crystal clear that this case is garbage and that she's done everything possible to get it back on track. Now, the reason I say that is because you notice today she spent she zeroed in on how unprepared, dare I say, lack of preparedness the prosecution has. And the only thing I can think of is she's really trying to highlight these people don't know what they're doing. These people are over here, got these men's whole lives in jeopardy, and they don't even know up from down, left from right. That's what I really think is happening. And we're watching it in 4K, we're watching it in real time. My screen is frozen, they say. What happened? I think when me and Mandy switched gears, let me see, stop sharing. Maybe when me and Mandy switch gears, I think that might have broke it. Here, let me do this. Let me remove my camera. And y'all can still hear me though. And give it a second. Maybe that's what happened. It seems like whenever I'm adding somebody to it, that's when the thing goes south. So now I'll bring it back. All right, and let's see if that works. What do y'all think? I haven't used my side camera in a while, so let me try that too. I do think that that's what she's doing. I think she's just trying to make a crystal clear case that this thing is garbage, that these people don't know what they're doing, and it's problematic. So because today just seemed like it's almost like pulling your fingernails out. Like, why are you doing this? Why are you doing this? And it has to be, I think, based upon what little I know, which is, of course, everybody knows, I know nothing. I think the goal was to solidify it. So she rolls up tomorrow or rolls up on Friday and says mistrial. Everybody will know it. So yesterday, when we started, we knew it based upon the motions and what we had seen up to this point. But technically, Judge Whitaker had not seen anything, the foolishness and the unpreparedness and the unprofessionalism that is the prosecution. So today, this is what I think. This is what I think. So yesterday she saw it. She's like, man, there's something wrong. Let me zero in on what I think is the problem. She probably looked through some files. She looked through some notes and noticed that Glanville was giving them a lot of grace to run court. And you heard it even with Love today with her explanation for why and how the former judge can be referenced in the recusal. I'm sorry, that he had been recused to the jury. Notice that while Judge Whitaker is talking to Steele, out of the blue, here comes Love giving directions. Oh, I'm going to tell him, so on and so forth. She didn't have to do that. So I really think Judge Whitaker knew something is wrong. These people really don't know what they're doing. Let me see if I can if I can apply some pressure to it. That's why she kept putting up that pressure on it and said, well, what are we going to do next? What are we here to work on? What do you have to do? Who's your next witness? She's talking, all that stuff is going to the state. And the defense, in their wisdom, they're just like, we're not even going to touch it. Not with a 10-foot pole. Y'all figure that out because this is your case. And I think that's what she's doing. I could be wrong, but I think that's what Siswit is doing. And I believe that's probably why it's been so nerve-wracking. Like, why in the world are you doing this? Why in the world are my lights not working? Oh, there you go. It worked now. Praise the Lord. But so that's what I think is happening. What do y'all think about that? Let me hear what y'all think about that. All right. People are concerned about the fact that I was frozen for some reason. I have no idea what that was about. I'm gonna turn this off in a second. All right, front camera's coming in a second. I just want to make sure if I don't know, maybe unfroze the system. I don't know. So now I'm bring that front camera back up in here. I can't do both of the cameras side by side. I was trying that yesterday and that was causing a whole bunch of havoc. So back here, let me know if I get frozen again. Yeah, I think she's getting enough evidence. She's getting evidence and proof that this case is hot trash, hot garbage. And from there, she's going to make when she makes her decision for a mistrial, though it seems nerve-wracking to us. You got to think about this also. Also, the way lawyers think is not necessarily the way that normal people think. And I'm not saying that lawyers are not normal. I'm just saying that the average Joe and the average Jane don't think the way that methodically that a thinks. So therefore, I think it's fair to say that we can make the case that they probably are doing something different. Not saying that they're playing 4D chess and we're playing checkers, but rather they just think about things differently and their approach to get to the end goal is different. So my thought process is that Judge Whitaker is laying out a case because she knows it's going to go to appeal. So if she lets it run all the way to a jury and they get a conviction, it's going to appeal. If she declares a mistrial, it's going to go to appeal. So either way, somebody else is going to look at this. And I think she's going to say, let me make sure unequivocally that I have everything in order, all my ducks in a row, all my I's crossed and my T's dotted in order to be successful. So it doesn't go to appeal and it doesn't get overturned. I'm sorry. It doesn't get overturned in appeal. That's what I'm thinking. But what do y'all think? Is this my pre-K law student credentials? Uh-oh, the pre-K bar. I love it. Is it still frozen now? Still? Okay, something here. I'm just gonna. I don't know what the deal is. I'm gonna restart my system in a moment. I don't know why. Okay. Retired agrees with me. The burden of proof is on the prosecution. And in times past, if you go back and watch some of those Glanville issues, he makes the prosecution and the defense prove themselves. And I think that the defense didn't have to prove themselves. I think the defense was more than within their rights to be like, yeah, no, we're not doing that, my guy. And it would have been okay. It was perfectly fine. I'm gonna just try like this and see if I freeze up. I don't know. Some people said that some things my picture's been frozen. Hey, I'm not again. Shout out. Hey, don't y'all get these lawyers out here jacking me up. All right. I already got Fonnie looking at me for RICO charges, but I think that's what's happening. I believe she's trying to make an airtight case that this needs to be, because most of us, the average Joe and Jane that tuned in yesterday was expecting a mistrial. But we were expecting a mistrial based upon those motions and everything that we saw from the defense the week and a half before. But technically, Judge Whitaker had not seen any of those shenanigans. We were going based upon what had been happening in Glanville's court. So that being the case, she has to demonstrate it. And if she's doing what I think she's doing, she's putting the prosecution, everybody sees it in 4K now. Everybody. They have no witnesses. They're still going through discovery. They're still doing all this stuff. But they brought this trial. And again, Weinstein brought it up. And I really believe that's what she's doing. We've been at this for 19 months. And y'all still don't have your list of lists of witnesses. You don't have your evidence in order. I think that's the problem. That's what I think is the issue. So we're expecting it to be like, hey, look, they're just alley-ooping it to you, dunk it, alley-ooping it, dunk it. And she's like, nah, it's not time yet. It's not time yet. It's not a good, we got to do she wants the dunk to be poster worthy. If you're familiar with like famous dunks in NBA basketball, they're poster worthy. Not every dunk is poster worthy. And so what she wants is a poster worthy dunk, in my opinion. She might totally be doing something different, but this is what I think Judge Whitaker is doing. What do y'all think she's doing? I was normal that one day too. Prosecution has the burden of proof. The defense is saying, show me what you got. There we go. And I think with Glanville, it has been a lot of, I don't know what you got. Prove that you need what they got, and all these other burdens on the defense. And now the burden is on the prosecution. I think therein is what we've been looking for. My question is, are people trying to be lawyers or YouTubers? Hey, man. Hey. I'm just trying to understand this thing. I'm trying to get out here and add some value to this conversation, Black law student. And I am trying to get my pre-K law bar license. No, I'm not. Yeah, I think I agree with you, retired. I like the way that she's going with this. I agree. I think she's going about it in a different way than what we saw yesterday. Because I think yesterday it didn't make sense to us. And I think we all left from there, especially before lunch. We were all like, man, this is lousy. What's going on? And I think that's why the defense has been so quiet, except for Shard and Steele adding the 2 cents. But I think that they realize, like, yeah, she's building a case for this to go south. I also think the state realizes that they're building a case. And that's why there's such a fever as relates to documents and folders and accordion folders materializing, because they realize that we're literally one objection away from being sent home. We're literally one objection away from getting kicked out of the big game. That's it. Oh, no, it's not done until she says it's done, Laura. You're correct. I agree. She's making sure everything is shown before she calls it. That's it. I don't think she can, because you could always say, well, I had this great idea. We were going to call in so-and-so, and they were going. Now you had opportunity. You just said you didn't have any witnesses. You said you're still sorting through your evidence. You said you got 900 hours of jail calls and this co-conspirator foolishness. I think she's setting them up for them to come back in there on Friday and say, y'all don't have to come back in on Monday because this is over with. That's just my little 2 cents, though. I'm really upset, Washington says, at the Rule 2020 order. Kayla tried to get. I didn't understand that, Black law student. If you want to add 2 cents to it, I didn't get, because I was driving, I was rushing in. I don't get what she was trying to do. Like, isn't Kayla a lawyer? Why is she in the courtroom? Shouldn't she be? I didn't get it. I didn't understand what we were doing. Like, shouldn't you be out doing law stuff, lawyer stuff? Like, leave this to us, like the pre-K law students. What are you doing? I didn't get what she was up to. If you can help me understand, or somebody else, feel free, at me so I can see your comment. I didn't understand what she was doing. I thought it was Rule 22. Is it Rule 20 or Rule 22? Why did she try to get a Rule 20, Black law student? I am on mute still. Just saw her. Right. She's been throwing out, and Mandy just said, yeah, she ended it by saying, if we bring the jury back. Very telling. She's been throwing out, if you go back and listen, she's been saying things like, if we go forward, if this case continues, if we bring back the jury. She's been throwing out breadcrumbs the whole time. So if this thing falls apart, we're going to all see it and be like, she said this. We knew it. Wait, Kayla is a YouTuber now? She still practices law, right? Hold on, y'all. Hold on. Kayla Bumpus is a YouTuber now? I don't think I would trade. I wouldn't trade my YouTube money for my possible law money. Oh, no. Oh, no. She's been getting out subtle hints the whole time. That's what I'm saying, Corey. Even as back as when we first met her, I believe she's been giving little hints of what she's thinking. And again, I could be 100% wrong. I'm not even pretending like I'm right. All I'm saying is, based upon what she's been saying and based upon what we see, I think it's very clear. I think she's setting up a case for her to definitely not be. Okay, now I'm gonna try it again. Hopefully that's. Let me know if my mouth is out of order or whatever. Yes, Kayla interviewed Woody on YouTube. Who is she? She is Kayla Bumpus wants to now be viewed as a media outlet. Girl, go get a case. Y'all wild, man. Oh, so that's what she was talking about? Really? I'm sorry. Look, I don't know. I'll probably trade her my YouTube channel for her law license. I would rather be doing law, I would think, especially as young as she is. Yep, she does. She does say this. She remains open and never seen the jury again. Mind you, she'll never see the jury ever. She's never seen them. Yeah, Kayla Bumpus has her own channel. She's the reason why Woody has a channel. Yes, that's true. She filed a motion to be considered under Rule 20, which is for media. Why? What? Why are you doing that? I don't get. I would love to know, like, what are you doing? Why are you doing that? Yeah, this is really wild. This is just when you think this case cannot get any odder. You know what? I'm expecting Woody to roll up in there and ask for a Rule 22. That's going to be that. Come on. What's the bets now? Where are you at, Vegas? That's going to be the next thing. Woody's going to roll up in there and be like, look, I'm a media outlet. I got a YouTube channel. I'm going to be doing trial vlogging. That's what I'm expecting at this point. The wheels on this bus have come all the way off. This case is totally, it is totally garbage. Yeah. At this point, I'm expecting Woody to roll up in here because as the peach rots is real. Oh my gosh. We watch YouTube. We definitely need a season 5. We definitely need a season 5. Oh my gosh. I'm surprised that they would allow her since she was part. I don't believe that Kayla Bumpus is the one that told Brian Steele, but let's just be honest. The prosecution knew that Melnick whether they liked him or not, whether he was always saying that he was Woody's attorney or not, they knew that he was not going to be there that day. That they knew on Friday when they asked for the second ex parte meeting, which, by the way, I'm going to do a video about that because that's crazy. So they already knew this. So not blaming but Kayla. I'm not blaming Kayla. I'm just saying she is literally, if she had not been a part of that ex parte meeting, it is very, very possible we would not be here at all. We would not be having this conversation. So that being the case, I'm just thinking maybe you should stay out of this mix. The YouTube money is not that good. Stay out of it. Just get out of it. And then to be a former attorney, that would be akin to Brian Steele or somebody else over in the defense just saying, you know what, now I'm going to go ahead and be a YouTuber. I'm doing these trial vlogs. I want to sit over there with Miss Sylvia. And yeah, that's it. I'm sorry. I don't know what she's doing. I would love, please, if somebody runs across it, please let me know. And I would love to hear, look, I'd love to talk to her if she want to rap. I just don't get what's going on. Okay, but why is she in the courtroom? She's an attorney. She's an attorney here in Atlanta and here, I'm sorry, and in Houston. Why are you worrying about this trial? There is so much. Yeah, I don't get it. But she can do what she wants to do. I'm not messing with her. Her reason was that she used other people's channels like they could copy. Yeah, that's fine. That is true. That is very true. Now, granted, I don't think most of them would do that because they're almost like a utility. Law and crime is almost like a utility. Like you can't just say we can only use this. I mean, now granted, they could, I guess, but I think that's a reach. But beyond that, though, you're still a lawyer. Aren't you supposed to be out doing lawyer stuff? I don't know. Is this like lawyer spring break? And you got other things to do? Like I thought you would be out doing lawyer stuff. I'm sorry. I ain't mad at her. You gotta do what you got to do. But it just seemed like a lot of huggabaloo for nothing. Just go do lawyer stuff. We need to quit calling it a season. A season is 3 months. Well, see, we're in season 5, though. This will be season 5. And technically, I mean, hey, I don't know how to determine it. I mean, I think we should be in season 5. I don't know. We watched YouTube. Yeah, we are in definitely season. What are we doing? What is going on? That is the season we're in right now. But no, see, lead attorney is done with, he's retired from law. His is different though. Just like me, I'm retired from being a school teacher. You don't see me going to try to be, assistant principals or something. I'm retired. You don't see me being grade level chair for first grade. I'm done. I'm done. So I just think, I don't understand what she's doing. Yeah. Okay. Thank you. We law student. It is Rule 22. Law student said, "I'm so mad." Why is it doing that? I don't get it. I have no idea why my camera keeps freezing, y'all. But I'm gonna go ahead and freeze. I'm gonna go to my side camera. Maybe something's with my camera. Yikes. Okay, I'm watching it over here. I have no idea why it's doing this. I'm so sorry, y'all. I have no idea. I'm not on Wi-Fi, but that's okay. I'm just gonna cut off. I'm gonna switch my camera and I'm gonna get out of here, but I'll make sure. Let me see. I'm just looking to see when is it freezing. Okay, on my end, it doesn't look like it's frozen. Okay, I don't know, y'all. I'm so sorry. Here, I'm gonna kill my camera. There we go. All right. So anyway, I'm just yapping and rapping at the moment. She wants to point out the injustice of the Fulton County Court. I think that's true. I think that's what Judge Whitaker is doing, present, not perfect. She knows she's playing both sides. She knows the details of the ex parte, so the state won't oppose her, and then may have helped the defense, so they won't stop her. I can get it. Look, she's supposed to be a referee. And so at the end of the day, she's not supposed to play either. She's not supposed to be pro or against either side, but just for the quote unquote law and make sure the rules are being played fairly. As long as she does that, I'm fine with her. You could be a lawyer and a YouTuber. There's tons of people that are lawyers and YouTubers. What I'm saying is that if she is primarily in Houston, but please understand, I don't think there's many people, I think Viva Fry is a practicing attorney. I know that Phil Holloway is a practicing attorney. Ashley Merchant is a practicing attorney. You don't see them sitting in a trial that's not related to them saying, I need a Rule 22 in order to be a third media outlet in this trial while they're supposed to be doing something else. That's odd. Now, again, I see practicing attorneys commenting on this. I see practicing attorneys giving commentary about court cases, and I think that's fine. And they're YouTubers. They're technically YouTubers. I just don't see why you're doing commentary on a case that you're not in, that's apart from your normal activity. To me, I don't understand that. We started season 5 on Monday. That's what I'm gonna say. We started season 5. See, there we go. See, that's what I'm talking about. Kayla's working out in Texas and the trials in Georgia. Now, she does have an office here in Atlanta. Hold on one second. What are you cool kids doing? All right, cool kid alert. Cool kid alert. Yeah, I don't know. Look, I ain't trying to disparage Kayla. Go make your money. I ain't mad at you. Oh, there's another cool kid. You look cute. Are you a high schooler?
Yes.
Are you look at you.
I walked to my classes and met 5 of my teachers.
Go over here and tell everybody you met 5 of your teachers.
Hi, you guys. So today was Fall Madness, which is basically the day when you can sign up for clubs and the such. Sorry, I'm trying to tilt it up.
Don't break my camera.
I'm going to break it. Your camera. So I signed up for a bunch of clubs. I signed up for Fellowship of Christian Athletes, Tome, which is like a reading club. I signed up for creative writing. I signed up for improv.
Okay.
And student council. So we're signing up for student council. I'll keep y'all posted. I start high school tomorrow.
All right.
Yay.
All right. Go get some rest.
I'm gonna iron my clothes first.
So you got to iron your clothes.
Yeah.
So high school,
My
high
skirt
school
is wrinkled.
You can't go to high school with wrinkled clothes. Okay. All right. I got you. All right. You didn't like the middle school clothes?
I didn't. Look at your comments.
No, don't bother. Leave my comments alone. What are you doing?
Comments.
Why art thou here?
It's people who like me.
Yes,
You
people
should,
like.
You should be like them, Daddy.
I should be like them,
Yeah.
but I don't know if I like you.
Yeah. Thank you for saying that you like my glasses. Yeah, high school does start tomorrow. Marietta likes to give us breaks, so they're starting us as fast as humanly possible.
They do have a lot of breaks. They start a month early because they literally take a month worth of breaks during the year.
It's 52 days until what's called?
Winter break?
Until fall break.
Fall break. Yes, I'm sorry. Fall break. I forgot about that.
And that's a week, and then
Winter break.
then Thanksgiving, then
Yeah.
winter, then spring, and also so many days where they just don't have us come in.
Yeah.
So yay! I'm very excited for high school.
Okay.
Thank you.
All right. Well, I guess we got
DWC fam.
Come on. So that's the rising freshman. Here's the rising
Senior.
She's gonna go. I don't like that. Oh yeah. Did you go pick up some toilet
I
paper?
didn't go buy it.
Go to the dollar store. Don't be wasting my money on real.
I'm going to the dollar store.
I want dollar store cheap.
Trust.
Evaporate while you throwing it.
If it rains, then it's.
Oh yeah, check the weather.
Your toilet paper is not going to.
Hey, I want to. Right, don't
It's
be.
so hot outside.
Yeah, don't be wasting my real toilet paper.
Oh, don't worry. Trust, I will not. Toilet paper in the school is tonight. So excited.
I do not approve of those braids, by the way. Did you finish painting your parking spot?
No. She's going to finish.
Go finish your
Firstborn, your braids are amazing. Get
wrecked. No, they're not. No, they're not. Y'all don't have to lie to these babies like that. Y'all don't have to.
I got a lot of compliments on them today.
That's because people ain't got no good sense.
What else happened? Most of the girls are meeting up at 8. They were talking about going to Waho before or after.
Can you explain what's Waho?
It's Waffle House.
Because
Waffle House.
Right. Do you want me to just send you a link so y'all can jump on from your phones?
No, I'm gonna go iron my
clothes. No, I've not. I've look. Go away, please. Please go away.
7 hours. You're insane.
Please go away.
Yo, this got me. You missed these. Oh my gosh, yes. Because I ran down. Stop. I ran down and I just sat in my favorite teacher's classroom for like 20 minutes. He was like, "Why are you still here? I thought I got rid of you last time." And I'm like, "I'm inevitable. I am inevitable."
What can I say?
Wow.
You're going to insurrect. You face
No.
property.
It's like tradition. So like at my school has a lot of traditions, but the seniors, we have a lot of stuff going on. But the seniors, they like toilet paper the school. Another tradition that I love the most is the baby powder at the football games. So I have this big tub of baby powder sitting in my room
for like 2 years.
Yes.
Really?
Yeah, I've had that thing for like a year.
It's like old. It doesn't even like work anymore.
What's it gonna do?
Well, we're not trying to powder it. Let's give it to Miles.
Go powder your nose
We're
or
doing
something.
a great job.
We did it at my school too. Exactly.
I do need to powder my nose, bro. I look shiny. I'm actually a disco ball, bro. I was outside painting in 80-degree weather. Talk about some shit.
Okay, so how much more do you got to do on your project?
I have to I outlined the petals of the flowers, and then that's iconic. That's actually iconic. That's
What?
So iconic.
Wait, what? We used to burn our names into the football field.
So iconic.
Like right, yo. Wait. Yeah, let's hide that one. Let's hide that one because there might. I don't know if the statute of limitation will run out on that one. That sounds like a crime. I don't know what that is.
But no, we
I don't know. You were saying that you were about to go upstairs.
No, you were talking about painting your parking spot.
Oh yeah, so I finished like the outline of the petals and to make sure like I had enough at least for that, and I didn't fill them in. So I have to finish one. I got two flowers done. So I need to finish the petals, and then I need petals on one, and I need to paint another, and then still paint my name in 2025 on it.
You didn't get done. You didn't get done, son.
Okay.
Jump scare.
Bye.
Bye, babies. Love you. You have ice cream in there. You don't need to go anywhere to get ice cream. Y'all have that ice cream in there. Oh my goodness. Take whose wrench away? I know, right? Look, crime. Look, crime might mean burning your name. Okay, you really gonna have to. All right, do that on your channel, Mandy. You have got to explain burning your name in the football field. I don't think we did anything. I don't think we had anything like that when I was a child. I don't think so. And we had senior skip day. Oh, well, we did toilet paper to school the first day. You're right. We did that. But that was it. I mean, but also please keep in mind, it was like a little red schoolhouse too. So, it was borderline, it was doing good to have a building. Yeah, you're going to have to explain that one. Did y'all close the garage, babies? Okay. We didn't do that. We didn't do that. I don't think we did. I'm trying to remember. Did we egg houses? I mean, we did some nefarious. I think we egged the school, maybe. for homecoming, but I don't think so. Like they have a whole shebang, like a whole week. They have a lot of traditions. They're like doggone Roman Catholics. Shout out to Roman Catholics. They got a lot of traditions. Oh Lord, here she comes. Oh gosh, here she comes back. Lord have mercy. I'm so sorry. How do you burn your name in the grass? You start burning your name in the artificial turf. You're going to right. That's I think my school had real turf, but still, like, how do you burn your name into it? I got a lot of questions. Halloween pranks, yeah, those. Okay, I can give you that for Halloween pranks. In Mobile, Alabama, they have a cannon for senior paint. Paint the names of Middletown. Okay, yeah, I can get down with that. I don't think we had anything. I really don't remember us having any kind of traditions like that. Y'all are wild with gasoline. Yo, I think we need to not put these up here, Mandy. I don't know if the statute of limitations are down. I don't know. I don't know where you get immunity from. You out here confessing your sins. This is not a look. You have not gotten use immunity. I don't want anybody saying, "Look, the feds are coming for Mandy. Mandy got locked up." I do not want to be a part of it. I can't put these back up here, Mandy. Y'all are wild. You use a wire coat hanger and shape it like your name, just like a tattoo. But I've never heard of that. Okay, can you give me some pictures? Y'all are wild. I got to get some pictures of that. Okay, I don't know how you all have successfully. Congratulations, girls. You have successfully gotten us off of the YSL case. All right, so tonight they're like, what did we accomplish? They're like, what did we accomplish with our lives? That right there is wild.com. All right, so let us do this. Tonight at 7:00, I'm going to do a recap tonight. So I would love for y'all to come. Maybe do more conspiracies. What do you think is going to happen? I'd love to hear what you think. Right, transplanted Texas. Look, I don't want to. I'm not telling the cops where Mandy lives. I don't know where she lives. She does not live in Nebraska. She does not live in Nebraska. Right next to Mr. Smith. Don't go to Nebraska. All right, I'm gonna get out of here. So tonight we'll do this at 7:00. I got a couple of guests coming in. I'm gonna solidify any other guests. I'd love to have a panel. That'd be dope. But I'd love to hear what y'all thinking. If you would like to, please make sure you got your camera on. Don't be like me, my camera freezing. When I get done, I'm gonna turn it off and restart it. But we'll be ready to rock and roll tonight at 7. So Eastern Standard Time, by the way. So the link is already up. The live stream's already playing. Get over there. Let's get ready to have some fun and talk about this case and where do we think it's gonna go? Because tomorrow, Thursday, they don't have anything. They're only coming back on Friday. So that's going to build up anticipation. I mean, they're doing their best to keep us all interested. I mean, come on. They know how to build anticipation for sure. But everybody, thank y'all so much. Thank you so much again to Mandy and everybody that came back even though I was gone. I appreciate y'all holding it down, keeping it in the middle of the road and not being like this case going off the rails. I appreciate you. I want to hear your theory on the ones indicted. I will on the ones indicated. I'm sorry. Hold tight. Not indicted. I'm gonna see tonight. We're gonna talk about that. Corey, you come on back. Make sure you bring your questions, and I will see y'all then. Everybody be blessed. Have a fantastic rest of the afternoon. I appreciate y'all. And until then, everyone, grace and peace. Take care.